So we are live. Good morning, good morning, good morning, everybody. How are you all? Good morning, guys. क्या हालचाल? बढ़िया. So welcome to the final rounds of the fourth Yes MOOT Code Competition 2024. आज हम लोग के जो 14 टॉप फाइनलिस्ट्स है वो लोग आर्ग्यू करने वाले हैं अपने प्रीलिम्स वाले केस में. एंड बाय द एंड ऑफ द डे वील नो हु आर दोस 5 पीपल जिनको आज अवार्ड्स मिलने वाले. ओके, सो द 5 अवार्ड्स दैट वी गिव ऑन द फाइनल राउंड्स आर ऑफ कोर्स द विनर, the first runner up, the second runner up, the best speaker and the best researcher. पांचों के ट्रॉफीज है, पांचों को सर्टिफिकेट मिलता है. Additionally, all those people जो फाइनल्स में गए हैं, they will get a finalist वाला सर्टिफिकेट. So even if you do not win something today, आपको स्टिल एक प्रूफ मिलता है ये चीज दिखाने के लिए आगे जाके कि आप फाइनलिस्ट थे. साथ ही साथ जो हमारे प्रीलिम्स राउंड के स्पेशल मेंशन अवार्डीज है एंड जो बेस्ट स्पीकर्स है उनको भी उनके सर्टिफिकेट आज रिजल्ट्स के टाइम ही दिया जाएगा. राइट, सो वी आर ऑल सेट. आर यू गाइज रेडी? आर यू गाइज रेडी? Where is the excitement? Okay, तो इससे पहले कि हम लोग स्टार्ट करें, we'll just let you know कि आज कौन-कौन जजेस है. So we have a bench of 4 judges today. We have विकास वोरा सर, मुस्कान गुप्ता मैम, विशिष्टा नायक मैम and myself. So we are gonna judge these 14 kids today. 7 of them will argue on contracts, 7 of them will argue on criminals, and based on all of their performances, last में we are gonna come up with the top 5 students जो आज ट्रॉफीज घर लेके जाने वाले. ठीक है, नाउ एक बार फटाक से हम बता देते रूल्स कैसे होते हैं. तो फाइनल राउंड्स के जितने भी पार्टिसिपेंट्स होते हैं, जितने भी फाइनलिस्ट होते हैं, आप लोग को प्रोफेशनल वाले क्लास में बैठना है पूरा दिन. यू आर नॉट अलाउड टू लीव द क्लास एट ऑल. योर फोन्स आर गोना बी हियर विथ मी. आपको ना तो फोन मिलेगा किसी से कॉन्टैक्ट करने के लिए, ना आप क्लासरूम छोड़ सकते हो. जैसे आपका प्रोसीडिंग होगा, प्रोसीडिंग के बाद यू कैन कलेक्ट योर फोन एंड सिट हियर, बट यू कैन नॉट गो एनीवेयर आउटसाइड टिल योर प्रोसीडिंग इज डन. खाने पीने की बात होती है तो आपके सारे फ्रेंड्स यहाँ पे हैं, अपने फ्रेंड्स को बोल दो कि जब यहाँ लंच ब्रेक होगा तो वो आपसे क्लास में आके पूछ लेंगे आपको क्या खाना है और ला के आपको खाना दे देंगे. बट यू आर नॉट गोइंग टू लीव दैट क्लासरूम एट ऑल. ठीक है, तो जिन लोग का स्टार्टिंग में यू आर लकी, जिन लोग का एंड में है कांट हेल्प इट, सॉरी. ठीक है, चलो तो फाइनलिस्ट प्लीज गिव योर फोन्स. मानसी मैम विल बी देयर विद यू इन द कोर्ट रूम. जैसे यहाँ पे आपके पहले वाले स्पीकर का खत्म होगा उसके बाद मानसी मैम इज गोना टेल यू गाइस एंड यू आर गोना कम ओवर हियर. ठीक है, तो आप वहां पे रहो. When I say कि phones आपको नहीं मिलेगा, that does not mean कि आप दूसरे तरह कोई इलेक्ट्रॉनिक यूज कर सकते. You are not allowed to use any type of electronic. मानसी मैम will let us know अगर आप कोई भी इलेक्ट्रॉनिक यूज करते हो and you will be disqualified तुरंत. Okay, ठीक है. Please inform your parents, your partners that आपके पास फोन दिन भर नहीं रहेगा, so that they do not worry. And उनको अगर आप चाहो तो लिंक भी भेज सकते हो. आपके ग्रुप्स में मैंने लिंक डाल दिया है. Yes, ma'am, please. Guys, jaldi, we are already 1 hour 20 minutes behind schedule. उठो. हाँ, finalists get up and go to your room. All the best. May the best boy or girl win today. हाँ, and also आपसे जो भी टीचर्स आपके क्वेश्चंस पूछने वाले, no hard feelings. We are here in the capacity of judges. It does not mean कि we do not like you guys or we do not love you guys. It's just that हम लोग सबको पता है कि जो भी 14 लोग आज बोलने वाले वो लोग बहुत ही धांसू लोग हैं, अपने अपने कोर्टरूम से जीत के आए. तो टू मेक जजमेंट इजियर फॉर अस हम लोग आपसे क्वेश्चंस पूछेंगे. प्लीज रोना मत, प्लीज डोंट हैव एनी हार्ड फीलिंग्स फॉर अस. इट्स जस्ट फॉर द सेक ऑफ द कंपटीशन. ओके, अंजुम को बोल देना ला देगी, बाद में दे देना, वो बाद में पिक कर देना उसको. नो, तो उसको बोल दे जो चाहिए, she'll get it. श्री प्लीज चेक दैट सबने अपना फोन दे दिया जो लोग जा रहे हैं. हाँ, फाइनलिस्ट प्लीज प्रोसीड टू योर क्लासरूम. CS प्रोफेशनल वाला जो क्लास है अपना, वी नीड टू मेक दिस क्विक, नहीं तो आप ही को कम टाइम मिलेगा. डन? मनस्वी मैडम डन? ठीक है, फोन्स यहीं पे रख देते अपने, है ना, नहीं तो वहां पे बच्चे आपको लोटपोट करके ले ही लेंगे। हाँ नहीं, यहीं रखे थे अपने। सो गाइस, फाइनलिस्ट के सारे फोन्स एंड इलेक्ट्रॉनिक आइटम्स हमारे पास आ गए हैं, तो वी आर गोना स्टार्ट विद द राउंड्स। वील स्टार्ट इन 2 मिनट्स एंड पहले कॉन्ट्रैक्ट्स वाले जो लोग हैं वो 7 लोग आके अपना प्रेजेंटेशन देने वाले हैं, उनके बाद क्रिमिनल वाले जो 7 पार्टिसिपेंट्स हैं वो प्रेजेंटेशन देने वाले, ठीक है? आर यू गाइस रेडी? यस, ओके, सो लेट अस बिगिन। So we'll start. Are the judges ready?
Yes.
Madam Judge, ready? Okay.
जब
ठीक
मैंने इतना अच्छा पोज दिया तो लिख कीजिए।
आई श्री कहाँ गया? श्री चले मानसी मैम की कब भेजना है? मानसी मैम को बोलो, वो उनको पता है। हाँ
अच्छे से लो। फिर शाम को हम लोग पूरे हो जाए।
सब जगह डाल दे। So we have our first contestant, Prutha Kashiwar over here. She will be representing the appellant, that is Vikas Shukla, in the case of Vikas Shukla versus Global Business College.
Hello, 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 hello. Should I start? Yes, please. Good morning, bench. I would like to give the memos of the. Good morning, bench. If it may please the Honorable Court, the Counsel Pritha Kashivar would like to argue on behalf of the appellant, Mr. Vikas Shukla, in the case of Mr. Vikas Shukla versus Global Business School, College. Sorry. If your lordship and ladyship may permit, the counsel would like to state the facts of the case. On January 20, Mr. Vaibhav Sinha, the Dean of Global Business College, Pune, announced the grand student meetup and invited students to participate by setting up their business ventures by allocating spaces in college garden in lots. Vikas Shukla, a student of Global, signed an allocation agreement on February 15th to secure lot numbers 12, 13, 14 for setting up food trucks, and he paid deposit of 1 lakh to that effect. He communicated with Professor Muskan, head of the Department of Human Resource Studies, about his plan to set up 3 food trucks, to which she asked him to send a blueprint regarding financial details. Vikas took various steps towards the setup and suggested 60-40 profit sharing model via an email on 13th March. To this, Professor Muskan responded positively, indicating her support. On 14th April, Vikas again sent an email to Muskan informing that due to logistic issues, he would like to vacate the lot a day after the meetup, that is 26th April, and she responded expressing her understanding and support. As per Vikas' plan, the food truck continued to occupy the lots a day after the meetup, but the college had leased the garden area to event management company for the exhibition. And due to trucks still occupying the lots, the college suffered a loss of rupees 30,000, and they decided to recover the loss from Vikas' deposit. Vikas contested the charges, arguing that the extended occupancy had been approved by Muskan, which constituted a valid alteration of allocation agreement. On this ground, my client has filed the current suit. If your lordship and ladyship may permit, I would like to state the issues of the case. First issue is where Professor Muskan was acting in the capacity of an agent of the respondent while corresponding with the appellant. Second issue is whether the allocation agreement is altered by the effect of correspondence between the appellant and Professor Muskan. If your lordship and ladyship may permit, counsel would like to state the arguments of the case. For the first argument, I would request the bench to take the reference of first case given in the memorandum, page number 5. Case is page number 5. The case is Syed Abdul Khalid versus Rami Reddy. In this case, the Supreme Court of India held that a principal is bound by the act of an agent if the agent acts within the scope of implied authority, even if the agent exceeds their authority. By applying the same fact, in this instant case, Professor Muskan, head of the department, she held a position of authority, and her positive response in point 6 and 8 of the case, in fact sheet, it is mentioned that she gave the letter of acknowledgement bearing the official seal and stamp of the college, and in point 8 she stated.
Counsel, where is it given that she gave the letter of acknowledgement? Point 6 says Vikas received the letter of acknowledgement bearing the official seal and stamp as requested by him. Who gave it to him or where it came from has nowhere been given.
It is given in point 6. Professor Muskan responded to the email by reciprocating Vikas' excitement, expressing that she would look into the same. And subsequently, Vikas received the letter. That means that she was the one who gave the email letter to him. And he also received the letter with bearing of the official seal and stamp of the college, which states that college was aware.
Could it so happen that she just collected the letter from the office or from whoever the board was and just forwarded it to Vikas? She had no involvement in making of the letter or issuing the letter or authorizing the letter. The board made the letter. She just collected it on behalf of Vikas and gave it to Vikas, given that they had a very positive relationship as a teacher-student.
Yeah, so my point is that she was acting as an agent in here. As she knew about all the meetup. In the first email, told that she gave the positive response to the email. So that clearly states that she knew about it and she was communicating with Vikas. So she does imply an authority of having an agent and principal.
Counsel, but tell me one thing. Why is your client consulting Muskan when it has been clearly specified that everything happens with the approval of the board? Is Muskan a member of the board?
It is not stated in the agreement that Muskan was not a member of the board.
So we are assuming that Muskan is the member of the board.
Because it is never, in the agreement, it is not stated that who are the designated members of the board. So for Vikas, he was communicated with Muskan. So he
has communicated with Muskan only because she is the favorite professor. That's it. No other reason.
Even if she was his favorite teacher, when he communicated with her, why didn't she told him that I am not on board? So please, you can query the same with the.
That's not needed. No, it has been clearly specified. And the agreement, when Vikas was signing the agreement, he went to the board, right? Agreement has been signed with the board. If you would please refer to point number 3 of the fact sheet. Right? So agreement has been signed by the board, with the board. Allocation agreement has been signed on 15th of February. They are communicating on 30th of March, which means it is evidently clear that it was supposed to be done with the board.
Yeah, but when in the allocation agreement, it is written that this allotment of agreement is between two parties, which is organizer, which is this agreement made at Pune this 15th day of February 2024 between Global Business College, hereafter referred to as organizer. That means like the college was in the term of organizer. So Muskan was also in it because she is a HOD. So as she is also a member of the college. So
is there somewhere written that HOD can be considered as a part of the board? Or we are just assuming it?
Can counsel give me just a minute? Okay, so as ladyship stated that it was never written in the agreement that was she a member of a board or not. So it was nowhere stated. Okay, I agree that she was a member or not. Then no, it doesn't, because if we consider participants were not aware who is in the designated board. Is it stick to? I have. Can I take? Yeah. May counsel, may the board, may the bench give me some time to state my arguments. So it was nowhere mentioned in the argument what is the composition of who is the designated member of the management board. If we consider Vikas was not knowing about the fact, okay. But Muskan herself never mentioned that she was not in the part of the she was not of the part of the board, and it was provided in the agreement. It was never provided in the agreement that who are the member of the management of the board, and if the Muskan wasn't a member according to.
The allocation agreement with the management of the board, no? So you know who is the member of the board.
But it was never stated there.
Where?
In the agreement that who is the member of the board. It was not signed in front of. There is never stated that when it was signed, the whole members. Sorry. So when he was signing the allocation agreement with the board was. It is nowhere stated that board was sitting there and there were members, so he can see that Muskan is not member. I shouldn't communicate with her or something like that. And because if she was not a member, he would have never consulted with her. As he is a student of the college, he would have never done that. And yeah, that's my statement. And I would like to raise second argument if bench may permit.
Just one thing. So you are saying because Muskan never said that she's not a member of the board. She said, I am on board with you.
Yeah.
She was excited, whatever. That is why she is on the board, and that is why we can say that she is an agent.
She is showing an implied authority, which is by Contract Act 187 shows that if an implied and expressed act have been done by a agent,
By an agent.
by an agent.
Exactly. So the law says that if you are an agent and then you do something expressly or impliedly, then that will be considered to be something done by the principal.
Okay.
But just because somebody, so for example, if tomorrow I come to you and I'm like, see, I am an agent of Narendra Modi and he has asked me to ask you to do this. Will I become an agent of Narendra Modi? No, because just by me saying that I am an agent, that does not make me an agent, right? Same way here, just because Muskan conducted herself in a certain manner, that does not make her the agent.
But she, at each and every point when he wrote the email again, she was again responding to it. And
Then you should sue Muskan for misrepresenting or fraud. If she was not the agent, the college is saying she's not the agent, she still misrepresented herself as an agent to you, go and sue Muskan.
My client, what my client plead to the judge was he wanted the 30,000 deposits back from the college, which were deducted from his deposit. And the second thing, that the civil in the Pune civil court, the decision was made, it was not in favor of him. So that's why he plead that. He never stated that Muskan should be more liable or Muskan should be the one who should be taking the charges or something like
See,
that.
counsel, what we understand is global business school can be liable only if the agency is proved.
Yeah.
Right? So let's keep it very simple. You tell me the ingredients of agency and then let's go step by step. If all the ingredients are fulfilled, we'll believe she is the agent and the case is in your favor. But if the ingredients are not fulfilled, I choose to believe that she is not the agent. Hence, global business school is not liable because they made the terms very clear.
Okay. So in point 11 of the fact sheet, the college argued that there was no explicit affirmation given by Professor Muskan to Vikas' proposal related to logistic issues. But in the mail of 16th April in point 8 of the fact sheet, it is clearly stated that she understands and she is on board with the Vikas and also asked him to let her know the further assistance from our end. Our end means she was with the board, she had some connection, or the college was aware that Vikas and Muskan is having the communication. But then why not college interfered and told Muskan to not communicate with then why didn't they interfere and said that you are not in the board, please don't communicate and mislead the students. Vikas should come to us and talk to us. Vikas would have done that. He's a student, obviously he wants to set up a business, then he would do that, no?
Counsel, the judgment you're referring to, this 1979 judgment, if you read the second point of this judgment, page 5,
Second point.
I'll just read this for you.
I will read it. Judgment?
Yeah. It says, the court emphasized that the authority of an agent could be either express or implied. If an agent performs an act that is necessary for the completion of the duties assigned to him,
Yeah.
such an act falls within the scope of implied authority.
Yep.
Is there a communication between the college and Muskan where certain duties have been assigned to her, since you're referring to this judgment?
If the bench may permit, I would like to take 2 minutes.
Please.
Okay, so Muskan, the Lordship wants to say that Muskan was never stated sorry, my apology. It was not given to her what were the role and responsibilities of the event. Then, if she was not given, then why she was responding in favor, like, okay, I understand, I'm on board with you, I consider your email, or I'm on board with you. that states that Vikas has interpreted that she has a capacity to work on it. If she shouldn't have stated it now. Vikas would have known that she is not in authority.
With due respect to your emotions, but at the first place, what I believe from this judgment is implied authority flows when there is certain express authority given to the agent. However, there is no express authority which is given to Muskan in the present case, of which you can infer that there were certain implied acts which she could have done, unfortunately.
Because when Muskan responded to his mail, she expressingly said that she would look into the same. So that is then expressed and implied authority she has stated.
Just a friendly gesture, nothing more.
It's not a friendly gesture.
It certainly is. But
If she was not in the capacity, why
see, forget
she was
about
saying
Vikas. I think let's just talk about Global and Muskan.
Okay.
Well, I just want you to prove some express authority which is given to Muskan. Is there any relationship between the two, Global and Muskan, where it is expressly stated that certain authority is given to her?
As she is a HOD of the Global Business College, she is
All HODs by default are the agents of the college. Sure about this?
yeah.
It changes the facts of the case completely, what you're saying right now. All HODs are the agents of the college.
In the matter of the event, she was the agent. That's
And
what I want to
what
say.
makes you say that?
In the matter of the event,
Right.
the setting up event of business, the event which was organized, she was an agent.
So at the first place, did Muskan approach Vikas, your client, or Vikas approached Muskan?
Vikas approached Muskan.
So how does that prove Muskan to be an agent of the college? If Vikas would have approached the office boy of the college, you would have said even he's the agent of the college.
The agency is the way she responded afterwards shows like Vikas misinterpret like he thought that she is an authority because she replied positively every time. And if you're talking before he approached Muskan, so he was not knowing, he was not aware was she or was she wasn't the authority of the board, agent of the board.
You sure of what you're saying?
Yeah, I'm sure.
Okay. So it's like if I have a kid with someone, by default the woman becomes my wife because there is certain consequential activity which has happened. तो हर औरत मेरी लुगाई बन गई.
For example, if you are going to a mall and there is a lifestyle franchisee there, and if there and if you are talking to any salesman there, and if you have purchased something.
Ma'am, I agree. अब आप जब salesman कह रहे हैं ना, salesman has been authorized to sell the products of the company. So there is an act which has happened prior, which I'm saying is an express authority. So implied authority flows after there is an express authority which is given to the agent, is all I'm saying. And this is completely based upon the judgment which you have referred to.
Sorry, the council is not aware about that.
Sure. Thank you.
Should I move to another argument? On 13th March, Vikas mailed Muskan. He specifically requested for letter of acknowledgement from college on point 5 of the fact sheet. And Muskan responded to the email expressing that she would look into the same. Subsequently, Vikas received the letter bearing the official seal and the stamp of the college. We state college knew that Muskan and Vikas were communicating about the matters of the event, for which college did not interfere, which clearly shows that Muskan was having enough capacity to deal with the same. So college can't, as in the fact sheet, in point number 11, the college can't state that Muskan was not Muskan was not authorized to grant approval for the same. They further claim that Professor Muskan had made no express affirmation to Vikas' proposal where she did it, and now they are denying it. Yeah. And in the fourth clause of allocation agreement is very problematic to be very specified that they have, as it is one-sided, it gives college the authority to deduct any amount from the security without prior notice. This breaks the very basic principle of audio alteram partem, which states that both sides should have an authority, should. Yeah, because he was in undue influence. So you are saying this contract is invalid? No, that fourth clause is invalid. Not invalid, but it is not appropriate to state a prior. What does it lead to? Legal point, valid or invalid? I'm not saying it's valid or invalid. I'm saying the fourth clause is not appropriate, as it is stated that it is stated that saying without prior notice, because it is very basic principle of contract that you shouldn't state the without prior notice statement, as it doesn't give the other authority to state their side.
Okay, this audio alteram partem is a principle of
Contract.
no, it's not a principle of contract. It's a principle of natural justice. It's a principle of natural justice, right? That without hearing the both the parties, you cannot give an order, right? Does it apply to individuals or private parties, or does it apply to the state or judicial authorities? So for example, if you come to a class and if your teacher gives you a punishment, can you stand up and say that, no, you didn't hear me, so you have violated my principle of natural justice? Can you say that to your teacher?
No.
Because your teacher is a private party, and principles of natural justice do not apply to private parties. They apply, as a matter of fact, to judicial authorities, to states, to those people who are at a position of, authority by law. So good argument, but I don't think this will be much applicable to this case, given that your client has signed the agreement.
Because he was having an undue influence. No? The college was a dominant party. So he has to sign the contract, even if, because he wants to go with his event, and as stated.
So if you're saying there's an undue influence, then this contract becomes voidable. Why don't you just get this contract voided?
So what you're stating is, I should state that this contract.
Just say that the contract, I want the contract to be declared as void. Because if there's undue influence, then this contract becomes voidable. Go ahead.
One more thing, that how would anyone know if the amount deducted from the security, the deposit, was reasonable or not? They have stated that sorry, I'm really sorry, but they have stated that it is that 30,000 was deducted from his deposit because of the logistic reasons, and the exhibition was to be allotted there. That's why 30,000 were deducted. But who knows that the 30,000 was the actual amount that should be deducted?
That's a stated fact.
It's given in the fact sheet. Point 9.
But who knows that 30,000 was the only
It's
amount?
a stated fact.
A college can also do any.
But the college is not
No, but
It's established fact.
But who knows that college have been deducting the 30,000? They can be deducting it on their behalf also, na? 30,000 can be deducted as he has already deposited 1,000 rupees for 1 lakh rupees. 40-60 proportion is there. 40% profit would be gone to the college. More they are deducting 30,000 from the deposit for the loss. And as it has stated that a student, the Vikas Shukla has boomed his business. So they sorry.
Counsel, you have 1 more minute. Wind up your second argument.
So you are saying that we don't know whether the college actually faced a loss of 30,000. So basically, if they didn't face a loss of 30,000, but they still deducted 30,000, it is fraud on behalf of the college. In your prayer, ask us to initiate proceedings of fraud.
फाइल किया है
आपको fraud कर लेना था.
केस ही गलत फाइल कर रहे हो आप
Chalo, you have 1 minute. Wind up your second argument. Else we are done.
Okay.
Second argument. 1 minute, huh?
So my second argument was that they shouldn't have deducted 30,000 from deposit as the alteration of agreement was not done, and Vikas had taken permission of Muskan and she also agreed it. I would like to proceed to the prayer. Yeah. If your lordship may permit, the council would like to move on to the prayer. In the light of facts stated above, issues raised, argument advanced, authority cited, it is most humbly prayed before the Honorable Court to order the college to refund the rupees 30,000 deducted from appellant's deposit, as the deduction was based on an unjust interpretation of the agreement, and reverse the Honorable City Civil Court's decision and recognize the email's correspondence as a valid modification of allocation agreement, and pass any other order that Honorable Court may deem fit in interest of
What
the
other order do you want? You've already asked for 30,000.
Yeah,
Right?
yeah.
That's it, no? What more do you want?
So the college is liable for it. So yeah, that's it.
Any more amount that you want the college to pay you for the harassment and costs? Any further amount? Compensation, damages, costs from college? No, just 30,000.
No, they have committed a fraud in the agreement.
So
file another case now
No, I'm just saying that they have committed a fraud. So they should be giving some compensation to Vikas. As like what?
Do you want the court to calculate the compensation amount
No,
now?
no. I would be the one who would be stating in behalf of my client. So
Okay.
at least 50,000 should be given.
Have you even consulted your client? Or just asked for it 15,000?
We before discussed it. So
Okay. Thank
we
you.
know about it. पॉकेट नहीं है हाथ में मुझे
Hello. Sorry. Good morning, bench. If it may please. Good morning, bench. If it may please this honorable court, this is Counsel Simran Poddar arguing on behalf of Global Business College in the case of Global Business College and Mr. Vikas Shukla. I would like to submit sometimes. If the honorable court may permit, I would like to address the bench as your ladyship and your lordship. If you much obliged, ma'am. Sure. If your ladyship may permit, counsel would like to state some facts. Sure.
3 important facts, that's it.
Sure. Fact number 1. Vikas Shukla confirmed his allocation of lots by signing an allocation agreement with the college, wherein he received a copy of receipt of deposit along with the allocation agreement from the designated member of the board. Without even thinking twice, he went to his favorite teacher, Professor Muskan. She was the head of HR department of the college, wherein he gave the details of the agreement and demanded that he will require a letter from the college bearing the official seal and stamp from the college. Because of some issues, Vikas updated a week prior that he would require the lots for a day more. He wanted to extend for that, due to which the college suffered a loss of rupees 30,000, to which he claimed that there was a correspondence of a valid alteration of the allocation agreement and thus he had not committed any breach. In turn, Global replied, Professor Muskan was not authorized as an agent. These were my facts. I would like to proceed with my issues. There are 2 major issues. First one, is there any agency wherein Professor Muskan is acting as an agent? And the second issue is if there is any alteration with the allocation agreement. I would proceed with my arguments. Argument number 1, related to agency. As per section 182 in the Indian Contract Act 1872, an agent is a person employed to do any act for another or represent another in dealings with third person. The person for whom such act is being done is referred to as the principal. There was a case which tells about the testing of determination of existence of an agency relationship has been explained by the Havan J of Allahabad High Court through a specific case law. Yes, so page number 10, 11 and 12. Loon Karan, Sohan Lal versus John and Company. This is page number 10, 11 and 12.
Which court is this?
Yes, sir.
Which court is this case from?
Sir, this is from Kerala High Court.
Allahabad High Court.
No, sir. He was from Allahabad High Court. Dhawan J was from Allahabad High Court. He determined the test of agency relationship.
So this is Allahabad High Court, na?
Yeah.
And where are you standing right now?
Sir, Bombay High Court.
How many judges were there in this case?
Sir, I am not aware about that.
One, it's written.
Okay, I'm so sorry.
How many judges are there here?
Sir, 4.
It does not have any value in front of us. This case.
So allow me a couple of seconds. I'll just. But sir, here clearly he has stated that agency depends on the nature of relationship in order to ascertain whether the relation of agency exists. The true nature of agreement or the exact circumstances of the relationship between the alleged principal and agent will be regarded, and it is found that such agreement in substance contemplates the alleged agent acting on his behalf and not as an agent in the agreement. The relation of agency will not have a reason here. No, sir, it is, you can refer that. It is recommendatory but not binding. Sure, sir, no issues. Sir, I thought it is relevant. I wanted to have you on it. Why, sir? It has been stated here that agency relationship depends upon this. Sure, sir, it is recommendatory. You are not binding upon it. So. I would move on to my other arguments. Yes, sir, agency. Communication with Professor Muskan. The communication clearly states, given under the facts, which is given under the facts, that Vikas went to Professor Muskan in excitement because she was her favorite teacher, just to let her know that he has been doing something with the college and participating in the event. Muskan gave advice as how he should plan for the event. Merely giving advice does not conclude that there is agency.
What are the ingredients of agency?
Yes, ma'am, sure.
According to me, employer-employee relationship amounts to agency. And
No.
in that case, this is the case of agency. So you only have to prove that Muskan was not acting as an agent.
Yes, ma'am, I will. Muskan is not acting as an agent. I would state about employee and agent. I would like to state some key differences between an employee and an agent. The key difference between the nature of relationship and level of control first is that level of control is different in both the cases. Employee is someone who works for an employer with direct control and supervision, wherein employee receives a salary. Whereas in case of agent is someone who represents and acts on behalf of somebody, wherein he does some work on a basis of commission or some fees paid to him. Remuneration is there, but in different forms. There is a fixed salary in case of an employee, but whereas an agent, depending upon the work, he charges some commission, percentage maybe, or a fees. There was a case also, I would like to refer that.
Can I keep an agent on a fixed monthly amount? Irrespective of the work the agent does, we pay him.
Yes, sir, in case of insurance company, it is the same. They kept...
Is it sector specific?
Yes, sir, maybe. Pardon, I'm not aware about this particular thing.
No, don't say anything not sure of. It's not sector specific.
Okay,
You can pay something to an agent on a monthly basis.
On page number 16, 17 and 18, a case is given from SAC, Mohanlal Jain versus Maharaj. Here at page number 17, there was a person, Mohabbat Singh, and his employer. He was working as an employee, and the employer was Maharaj, wherein he was so much closely connected with the employer that he also did signatures on behalf of him on letters of military things, ministerial acts. I'm sorry. Ma'am, I would like to state, I'm remaining with many arguments. I need more time. I'm requesting. In this case, agency was not proved. Where Mohabbat Singh was acting as on behalf of this Maharaj, but still the court held that he was not an agent. This is a judgment of Supreme Court.
Why did the court held that he is not an agent?
That because he was working as an employee and he was kept on a specific set remuneration, and he was working as an employee and he just did his part of work, but he was so close with the employer that he used to sign some ministerial acts letters.
Okay. And how do we apply this case in the existing case?
Ma'am, here Professor Muskan has not given any apparent authority, neither in writing or implied anywhere. So how shall we consider that Muskan was having any authority here?
Okay.
How would we know that Muskan ma'am was in authority?
If you refer to point 8 of the fact sheet,
Yes, sir.
it says, "Thank you for the update. I understand and on board with you."
Yes, sir.
Can this not be a case of implied authority where she states that I'm on board with you? And at the same time, it further states, do let me know if any further assistance is required from our end.
No, sir. Maybe our thing is, maybe it is in generic terms, because Professor Muskan was acting as a communication link between Vikas Shukla and the college.
Which means an agent.
No, sir.
So is there a difference between a facilitator and an agent?
Yes, sir.
There is.
Yes.
So here you're saying she is acting as a facilitator and not an
Yeah,
agent.
just a communication link, not as an agent.
So from our end and from my end makes no difference.
No, sir, there is a difference, but in general terms, we say that. Means if Vikas would need any further assistance or if he need any further help from Muskan, can I give you a real example?
Please.
Sir, if here in our classes, yes, Academy is arranging a moot court competition, and I want to apply for that. Means here the college is arranging something wherein Vikas has to apply, and there it is specifically said in the facts that Vikas have to reach the college, and with the board he has to sign an allocation agreement, which he did. So in the relevant case, I would tell that if I have to communicate with Vikas sir, but I have a bond with Muskan ma'am, so I would please Muskan ma'am ki please let me means act as a communication link. If I am not comfortable with talking to Weber sir or anything, so maybe I would ask Muskan ma'am if she is my favorite teacher to help me out.
I honestly could not link the two. The example which you referred to, and probably just tell me one thing.
Yes.
She could have simply stated, no, from my end and not from our end. When you say our end, it essentially indicates that she is representing the college.
Yes, sir, but in normal cases you are right. But in this specific case, it is not relevant because Muskan ma'am is saying here that I am assisting you with the college. If you need any further help from me, means if Vikas need any assistance, he would go to Muskan ma'am and ask this. I need this to be done. So she will tell that okay, I will do it with the college. Okay. She is just acting as a communication link and maybe just advising or helping him.
Fair.
Yeah, because in the first e-contract, Vikas demanded, he said, as per regular business practices, he would demand for an official seal and stamp from the college. Whereas in the second case, yes, she was helping, ma'am. Yes, ma'am, but here my client is not liable for this, no?
Counsel,
Yes,
you said that Vikas signed an agreement with the
college, board
board or college.
Ma'am, board of the college who was designated to do these acts.
Okay. Is HOD a part of the college?
Ma'am, Professor Muskan was the head of HR department.
Is she a part of the college or not?
She is a part of the college.
Right.
But she is not the part of the management board who was designated to do
Okay,
this
okay.
work.
We'll get to that. In the original fact sheet,
Yes.
the second fact, the last line,
Okay, ma'am.
starts with the interested students.
Yes, ma'am.
Can you read that out for me?
Yes. The interested students should negotiate with the college, reading the profit sharing agreement and sign an allocation contract.
Stop
All-
right there.
Yes.
Interested students should negotiate with the
College.
right, and this negotiate about profit sharing and sign an allocation agreement with the
College.
exactly. Is HOD a part of the college?
Yes, ma'am. She is.
So then obviously if Vikas approached
But
HOD,
ma'am, in-
who's a part of the college,
But ma'am, in further fact, it is stated that he has signed the agreement in the college office with the management board. That means the college management board was designated to do these acts.
and who is to say that Professor Muskan was not a part of the board?
Ma'am, there is apparently nowhere expressly given that she was a part.
Is it expressly given that she was not?
No, ma'am.
Then are we assuming things or are we presuming things?
No, ma'am. We are not presuming nor assuming. But according to the states, we are stating these things that she was not the part. I have to prove this thing that she is not the part of the college board. I would like to state another argument. Vikas demanded for the official seal stamp by the college by saying as per regular business practices. If he was aware of so many regular business practices, he would have demanded the same for the second contract where he is telling that there is an alteration where it was not.
Counsel, just one thing with respect to whether Muskan was an agent or not.
Yes.
Let's stick to the facts and discuss about it.
Sure.
In the first email that Vikas sent to Muskan, he said, I wish to avail lots 12, 13 and 14, right? Now, if you see the allocation agreement, second paragraph, it says the participants will be allotted lots which are to be later allotted based on a request made by them. Can we stretch it a little and say that request has to be made to the board? Go to the allocation agreement, second paragraph. Whereas the participant is seized and possessed of or otherwise entitled to the premises at lots to be later allotted to the participant based on a request made by them. Obviously, it has to be made to the board.
Yes.
Right? Now, in the entire fact sheet, Vikas tells about, with Muskan that he wants to avail lots 13, 14, 15, or whatever, 12, 13, 14, right? And he gets allotted those lots.
Yes.
So if you come and tell me that you want a particular organization of whom I am an employee to do something, and if I get that thing done, doesn't it by default mean that I am an agent? Because
No, sir.
you are discussing with me about the lots you want, and I'm getting you the lots to you. Who else would you go and discuss, and who else would give you the lot if not the board members? So this evidently says that she was a board member, and secondly, even if she weren't, by principle of estoppel, she will be bound by her acts, and the college will be bound by her acts because she showed herself to be an agent to a third party.
Yes. But sir, there is no fault of college in this. She pretended that she was an agent, maybe.
There's actually no fault of Vikas in this. If you want, you can go and sue Muskan. Because she didn't have the authority, yet she misrepresented on behalf of the college. Go sue Muskan. Don't sue Vikas.
So I
No?
would still stick to my argument wherein Vikas did not demand it for the official seal and stamp during the
Do
second
we need
contract.
official seal and stamp in
Yes,
an
sir,
e-contract?
Yes.
E-contracts require official seal and
But sir,
stamp.
the original allocation agreement was done physically.
But so if an agreement is done physically, it cannot be altered via e-contract. Is that what you're saying?
But sir, there should be an authority to do that, right?
No, that's a different matter. Basic principle of contract law. If you have a valid physical contract, can it be altered by an e-contract?
Yes, sir, it can.
It can be. Do e-contracts need sign and seal?
No, sir, but in the specific alteration, I would refer that to a case law.
Okay.
I would tell that to the case law. Argument number 6. The allocation agreement was signed between the Global Business College and Mr. Vikas Shukla, through which a right to use was transferred, which is 20th April to 25th April for the availation of lot. Any material changes or alteration with respect to this agreement shall only be brought into effect through valid consent of both the parties to the contract, right? Means the parties are the management board on the behalf of college,
Party is Global Business School.
Global Business School and Vikas Shukla.
Correct.
Yeah.
So
ma'am,
party
these
is not
are
the management board, na?
Yes, ma'am.
Is Professor Muskan a part of Global Business College?
Yes, she was.
Yes, then what is the problem in that?
But ma'am, she was not the part of the management board.
Correct.
But
Consent
sir,
of party is needed, na? Party is Global Business College.
But ma'am, Global Business College was not aware about this.
What?
That there has been, and okay, can you please go to the fact sheet and read point 8. 7, I'm sorry, 7. So ma'am, the subject of the contract is update on preparation for the meetup. Merely any update does not amount to alteration of the contract. But sir, I would like to state a case law. SR House Private Limited on page number 7, 8 and 9. SR House Private Limited versus ArcelorMittal Nippon Steel India Private Limited. Sir, at page 7, novation, rescission or alteration of a contract under section 62 of Indian Contract Act can only be made with the agreement of both the parties. Both the parties have to agree to substitute the original contract with a new contract or assign or alter it. It cannot be done unilaterally.
Council, that is what we are saying, that Global Business School can alter it, right? But Professor Muskan is a part of Global Business College, na?
But ma'am, the college is not a person na, that it would enter into a contract. On behalf of the college, no, there has been, the designated board is there to do all these things.
Acha, college is aware about the communication that is going on between Muskan and Vikas?
No, ma'am.
It is going through official email IDs.
Ma'am, nowhere expressly it is given that college ID is being used here.
Official mail, na? Okay, if you could come to point number 8 of the fact sheet.
Yes, ma'am.
The reply says, thank you for the update. I understand and I am on board with you. Do let me know if any further assistance is required from our end. College knows that, right? Then why is college not responding to
Ma'am,
it?
college does not reply. Muskan responded. Professor Muskan responded.
But college
to
is
her.
aware of the fact, no, that Muskan is updating or Muskan is speaking on behalf of the college.
Ma'am, but Vikas, when firstly originally.
Achha, when I say whatever is needed from our end, what does it mean?
Ma'am, maybe in generic terms, it could be said that what is needed on our end. In generic terms, we would.
I would say what is needed from my end.
So when she uses from our end, that is generic. But when Vikas uses update, that is of a lot of importance. That changes your entire case, huh?
Sir, I would like to state some case laws here.
Counsel, you have 1 more minute, wind up your argument.
And can you please allow me 2-3
No,
more?
1 minute, final.
Ma'am, but I would again like to stick with the facts only.
Go to the prayer.
And also to the. Please let me complete.
You have 1 minute, 45 seconds are left.
Ma'am, in
Continue.
the allocation agreement, it has been clearly stated that any material changes in the last thing, last 6th point, any material changes or alteration with respect to any part shall be brought into effect only through a valid consent of both the parties. The parties were the management board and Vikas. But sir, on behalf of the college, the board is doing all the contracts, na? Sir, the Vaibhav Sinha, who is the dean. But sir, he is the dean of college. Why, sir? Well, he has arranged.
If what Dean says it matters, then what Professor Muskan says, that also matters.
Ma'am, dean is above the. Ma'am, I would like to go with the prayer.
Go to the prayer.
Therefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, the Honorable Court, if it may pleases, please dismiss the appeal from Vikas Shukla and declare that Professor Muskan was not an agent. No. Why would I have a case law for the prayer?
Counsel, start. Yes.
If it may please the Honorable Court, I, Ikram Mohammed, counsel appearing on behalf of Vikas Shukla in the matter Vikas Shukla versus Global Business College. If it may please the Honorable Court, the counsel would like to address the bench collectively as your Lordship. Much obliged, your Lordship. If your Lordship may permit, the counsel would like to proceed with the facts of the case.
Just two important facts.
Okay. Vikas approached his favorite teacher, Professor Muskan, who is the head of HR department. Professor Muskan asked Vikas to send a business blueprint by email, including the financial details, and Vikas communicated the same on 30th March 2024. And the second one, Vikas on 14th April sent another email regarding some changes in the allocation agreement, to which Muskan replied on 16th April. And after the meetup was concluded, Vikas received an email from Global notifying the deduction of rupees 30,000 as an additional occupancy of lots 12, 13, and 14. If your Lordship may permit, the counsel would like to proceed with the issues of the case. Issue number 1, whether Professor Muskan in their action was acting within the scope of authority as an agent of the respondent. And issue number 2, whether the alteration to the allocation agreement is valid and enforceable under the applicable contract law principles. If your Lordship may permit, the counsel would like to proceed with the arguments of the case. As per Section 182 of Indian Contract Act 1872, it defines the term agent and principal in the context of agency. Agent is a person who is employed to represent another person or to perform an act on behalf of the principal in dealing with the third parties, and the principal is the one for whom the agent works or represents. The principal delegates the authority to agent to act on their behalf. According to Indian Contract Act of 1872, an implied agency is a relationship between two parties where the agent's authority is implied by the circumstances of relationship then being explicitly stated. It is stated in the section 186 of this act. By applying this provision, your Lordship, there exists a principal-agent relationship between Professor Muskan and Global. There is an implied agency between them by virtue of their conduct. Professor Muskan, by her actions, she's clearly justifying that she is acting as an agent on behalf of the Global, whether it be profit-sharing ratio from allocation of lots, or providing a letter of acknowledgement, bearing official seal and stamp, asking for the business blueprints, or financial details regarding the meetup. Her actions are clearly depicting that she is acting in the capacity of an agent to the Global. Your Lordship, it is clearly stated in the fact sheet that students should negotiate with the college regarding the profit sharing ratio, and all the participants must conduct their business activities only with the approval of the board. In the first very instance, Professor Muskan asked Vikas for the business blueprint and the financials. She asked my client to communicate through an email, and the subject of email was only the proposal of profit sharing ratio for the meetup only. And also when my client, Professor Vikas, asked for the lot number 12, 13, and 14 and the profit sharing ratio based on 60-40 model, where college takes 40%, he said that please confirm the same. To which Professor Muskan replied in positive. If she was not having any authority, she could have just simply denied that she is not having any authority. He also asked for the letter of acknowledgement, which was received by him later, bearing official seal and stamp of the college, which clearly depicts that Professor Muskan is having authority. She is representing college, because it was clearly stated, it was the dean of the college clearly stated that the profit sharing ratio will be discussed only with the college. And also the allocation of lots, it will be given with the permission of the organizer. Organizer here means college only. And the basic main terms of the allocation agreement here are, one is the profit sharing ratio and another is the allocation of lots. Both of them were approved by Professor Muskan to Vikas, which clearly depicts that Professor Muskan is having the authority to allow the same. Your Lordship, it is stated in the fact that she is the favorite teacher of Vikas. Just stating the fact that she is the favorite teacher of Vikas, it doesn't mean that she is not having any authority. She was definitely having that authority. She was in that capacity that she could discuss the profit sharing ratio, allot the lots which he wished to avail, and provided the acknowledgement letter bearing official seal and stamp. If it was just a normal conversation, she would have not asked for the business blueprint and the financial, and they would have just communicated in a normal way, not through an email which was having a proper title, that is proposal of sharing of profit sharing ratio. Another noteworthy point, your lordship, is that she clearly mentioned, it is clearly mentioned in the point number 2 in the allocation agreement that the organizer and the participants agree that they shall use the premises under the permission of organizer only. So when Vikas asked for the lot number 12, 13 and 14 to Professor Muskan, after communicating the same with Professor Muskan, he got those lots allotted only. That means she is having authority. If she was not having any authority, she could have just denied that she is not having that much of authority to discuss the profit sharing ratio, to allot the lots, which are the basic components of a allocation agreement.
What are the sections we are citing here?
Section 182 of Indian Contract Act. Agent principal relationship, I'm stating. Implied agency 186, yes.
Counsel, is there an employer-employee relationship between
Yes, your lordship, there is an
Global
employer.
and Muskan?
Yes, your
There
lordship.
is.
Yes.
So by default, every employee happens to be an agent.
No, your lordship, it's not necessary that every employer-employee relationship will be considered as principal-agent relationship, but in certain circumstances, it can be considered by the virtue of employees' actions. Here, Professor Muskan's actions are clearly depicting that she is having that authority, means she is acting on behalf of the college, so there exists a principal-agent relationship between Professor Muskan and the Global.
So what is that line of difference between an employee and an agent?
Employee works as per the employment contract, which is entered between the employer and the employee.
Right.
And agent acts on behalf of the principal.
But I think both are contracts of employment.
No, your lordship.
It's not?
No.
So an agency is a contract for employment.
Employee relationship.
Is a contract of employment.
Yes.
And principal agency relationship is
Principal agency relationship?
also a contract of employment.
No, it's not a contract of
It is a contract for employment.
Yes. a
Which
contract.
means an agent acts in his independent capacity whatsoever.
Yes, agent can act in his independent capacity.
Would that not be breach of the basic terms of agency, that he can only act within the ambit of authority given to him?
Implied authority, under implied authority. If it is for the benefit of the principal only, then he can act.
What comes first, express or implied?
Express?
Express
It
authority
can
or
be
implied authority?
express or implied authority.
So implied authority can flow without without any express authority given to the agent.
Agent. Yes.
So prima facie there can be implied authority without an express authority.
Yes.
Sure about this?
Yes. If it is for the benefit of the principal, it is.
Okay. And
If the agent is working for the benefit of the principal,
to discuss profit sharing ratio with someone is such an important term that the person by default is treated as an agent or a representative.
yes, because profit sharing ratio was the main element of the allocation agreement, which Vikas discussed with the Professor Muskan, to which she agreed.
So if that is discussed with any person, automatically the person comes within the scope of an agent.
Not with any person, but here Professor Muskan was having authority
And that comes from?
by virtue of her acts. If she was not having any authority, she should have just denied that she is not having any authority.
She never accepted also.
She accepted.
Where?
When it is written there, Vikas, after receiving her assent, he started to preparing for the meetup. Why would he require her assent then?
Okay.
Counsel, do you have any case law that supports your argument, which says that authority can be implied also? You can be an implied agent. Any case law that supports that?
Yes, your lordship. Your Lordship, in Chairman LIC versus Rajiv Kumar Bhaskar, it is stated.
Which page are you referring to?
Last page.
Okay, United India, no. Have you submitted that?
Yes, yes. After that. Yeah. It is that the relationship of principal and agent can only be established by consent of principal and agent. They will be held to have consented if they have agreed to what amounts in law such a relationship, even if they do not recognize it themselves, even if they have professed to disclaim it, but the consent must have been given by each of them, either expressly or by the implication of words or consent.
And how do you show that consent was given by college to Muskan in this case?
Because when Professor Muskan, by her acts, it states that she was given.
No, Muskan's act states that. Now let's talk about the college. You need
Because
college's consent also, no?
College, the dean in the second point of the fact sheet states that the interested student should negotiate with the college only regarding the profit sharing ratio.
Right.
So that when my client, Mr. Vikas, communicated with Professor Muskan, it means that Professor Muskan was having somewhere the
Just because your client went and communicated to Professor Muskan?
No, if she was not having any authority, she should have denied at that point of time.
So I
That
think then you
means
should,
Professor Muskan is having authority.
just because she did not deny.
Yeah, she did not deny because it was the most important thing that
We get that. That is all sorted. My only question over here is, show us where, so you just refer to a case law which says that both the parties need to consent for a principal-agent
it
relationship
can
to
be
be there.
expressed or it can be
Yeah.
implied.
Show us how the college has given consent, either express or implied.
Because Professor Muskan is dealing with that. Professor Muskan,
That is Muskan's consent. Where does the college's consent come? Is there anything in the fact sheet which shows that college did something which shows that it gave consent or something like that? Anything that shows that college has given consent. You prove this and the case is in your favor.
Your Lordship, in point number 10, it is stated when the global denied that Professor Muskan was not authorized to grant the approval for the same, that is for the alteration of the agreement. They are just saying that she was not authorized for the same.
Repeat that again. What did you say?
When the college stated that Professor Muskan was not authorized to grant the approval for the same. For the same here means she was not authorized to alter the allocation agreement. But they are not denying that she was not given authority for the profit sharing ratio, allocation of lots, or asking for, but means that she was having that authority. She was in that capacity.
Anything in the fact sheet other than this where the college has conducted in such a manner, positively or negatively, which shows that they have affirmed Muskan's whatever she has shown, whatever she has pretended to be in front of Vikas?
Allocation of lots. Of lots. The second issue of the case is whether the alteration is valid or not. Your Lordship, it is the valid alteration because for my client, if she was, if Professor Muskan was having authority to discuss about the profit sharing ratio and also about the allotment of the lots, which are the main terms of the allocation contract or allocation agreement, then obviously for alteration he would communicate with the Professor Muskan only. When he communicated with Professor Muskan regarding the changes in the terms of allocation agreement, Professor Muskan replied to that, thanks for the update. That means Professor Muskan was aware about the terms of the allocation agreement, and she said that she is on board with her, and if he requires any further assistance from our end. To my client, Your Lordship, I require some more time, please. By virtue of her act, so when Vikas communicated with her regarding the changes in the allocation agreement, to which she did not reply in negative also, that means she was having authority, she was having that authority. Valid alteration, there should be mutual consent by both the parties or consensus aided a meeting of minds. There should be a agreement prevailing before the alteration, and any alteration will give rise to the new contract. So the both all the three things are present. How? Because for my client, Professor Muskan was having that authority. If she was having authority regarding the changes in regarding discussing the profit sharing ratio, from allotting the allocation, from allotting the lots, which are the main things in the allocation agreement, that means she was having authority for the same. Because how would my client know that she is not having the authority for this thing, which made my client believe that she's having the authority for the same. So that's why he communicated with her. And when he communicated with her, at that point, Professor Muskan did not deny that she is not having authority for the same.
Can you amend? So the allocation contract agreement was a physical contract? Allocation agreement. No, allocation agreement is a physical contract. They have signed it. Go through paragraph number 3. He went to the office and signed it, right? It's a physical contract, and this conversation is happening over emails. Can an email, can an email or an e-contract alter a physical contract?
Yes, as per Section 10 of Information Technology Act 2000, it can be. It's valid. That e-contracts are valid, or they cannot be, we cannot just say that they are unenforceable just because they are done through the electronic means.
Council, move on to the prayer.
Cases. Pray. In the light of facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before the honorable court to set aside the decree of the Pune District Court and reimburse the amount 30,000 to Vikas Shukla or any other order at the court may deem fit in the interest of natural
What
justice.
other order do you want?
That take the amount from the Professor Muskan.
So that you have already asked now. What other order do you want?
30,000 from Muskan.
30,000 from Muskan also.
No.
Then
Reimburse that from Professor Muskan.
that's it.
If college is stating that they are bearing any loss.
But that's not your problem. Why are you asking that in your prayer? That's not your concern anyway. That's not your concern, na? College पैसा दे रहा है कि मुस्कान दे रही है? How does it matter to you? You need your money back.
College?
When you ask for reimbursement of 30,000,
To my client.
yeah. So whether the college is giving it to you or Muskan is giving it to you, how does it make a difference
I
to
am
you?
saying to reimburse the amount. If the college is stating that they are bearing a loss of 30,000, reimburse it from Professor Muskan and give it back to Vikas.
When you ask for any other order, na, what other order do you want? 30,000 दे तो दी, अब क्या चाहिए बच्चे की जान?
As the court may deem fit.
But we don't deem fit anything else. That's fine. शगुन के नाम पे 1 रुपया. ठीक है?
Hello. 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 Good morning, bench. If it pleases to Honorable Court, this is Ashay Kumar, the counsel appearing on behalf of respondent in the matter of Mr. Vikas Shukla versus Global Business College. If the court permits, the counsel would like to move on the facts of the case.
Just two most important facts. We are aware of the facts.
Then enough. One.
One fact that you want us to pay the most attention to.
The appellant had signed the allocation agreement in the college office, deposited the fees, and received the receipt of the deposit amount and the receipt of the copy of an agreement from the designated member of the management board. If the court permits, the counsel would like to move on the issues of the case. Whether Professor Muskan was acting in the capacity of agent of the respondent while corresponding with the appellant, whether the allocation agreement is altered by the effect of correspondence between the appellant and the Professor Muskan. If the court permits, the counsel would like to state the arguments of the case. I would like to start my argument from the definition of agency as per section 182 of the Indian Contract Act. The agent is a person employed to do an act for another or to represent another in dealing with the third person. In the case of P. Krishna Bhatta versus Mundilal Ganpati Bhatta, it is a Madras High Court case. The important thing in this case is the representation of another in business negotiation with third person so as to bind such other person by his own act as if they were done by the former is of the presence of this relationship in the agency and distinguish between the agent and another person who act on another. And the second line, the representative character and the derivative authority may briefly be said as a distinguished feature of the agent, of an agent. Every person who acts for another is not an agent. The main important thing that I want to convey by this act, by this case. Another case is of Loon Karan Sohan Lal versus Firm John and Company others. In this, the true nature of relationship of agency is discussed, which is to create a legal relationship between the principal and the third party. In our matter, the appellant went to the Professor Muskan after signing the agreement, and he went to express his plans to set up the operation of the food truck, not to create any legal relationship between my client and the appellant. He just went as a firm mentor and to discuss his business plans, not to create any legal relationship. Even in the email he sent to the appellant on 30th March 2024, the appellant has used the word encouragement, which is used while which is not used while entering into a contract. It is usually used as a guidance which is provided by a mentor or a teacher.
In the subject matter, he has used the term proposal, which is very much used in a contract. Proposal, promise, offer, these are synonyms.
It is true that he has used the word proposal, but he has used a proposal as a proposing his business plans, not to create any contract or accepting any contract. He has proposed a business plan which he wants that his teacher just guide him that it is correct way to go or not. Should he make any changes or not in his business plan?
No, it is proposal of profit sharing. So if you go through the chain of events, the college in his announcement said that the students must negotiate with the college regarding the profit sharing agreement, right?
Yes, Your Lordship.
Then he went, got the allocation agreement, went to Muskan. Muskan told him, "Ki bro, give us the financial details and your business blueprint." Then he went, typed a mail in which in the subject line he said, proposal of profit sharing. The principal had said that profit sharing you have to negotiate with the college, and
Yes.
he is doing exactly that while sending this email to Muskan.
But-
So I think there is pretty much an intent to create a legal relationship with respect to the profit sharing ratio. Or he could have just written, information regarding profit sharing, yeah, blueprint of the email. He specifically said proposal of profit sharing.
I understand your consideration, Your Lordship, but I beg to differ because the Dean of the college has clearly said that the students should negotiate only with the board, and there is no mention that the Professor Muskan is a
How
part
do you
of the
know
board.
she is not a member of the board?
It's not mentioned in the,
But we can imply it, no?
but there is in my further arguments, there is no act by the principal which implies that the Professor Muskan is an agent.
Like, for example, what act should have been there that would have implied that she is the agent?
Uh, it could be that she could be directly dealing with the allocation agreement, or she could be in an administrative service and administrative management of the college, but there's no clear facts.
Yeah, she is the HOD.
But all the HODs can't be the member of the management board.
Okay.
There are lots of subjects in the college. Yes. So while in this case, the Professor Muskan, while dealing with the appellant, was just acting as his mentor, and for the college, she is just an employee. To support this argument, the council would like to appear to a case. Just give me a minute, ma'am. Just want to clear the last issue. Just 1 minute. Yes. In a case of Lakshmi Narayan Ram Gopal and Sons Limited versus Government of Hyderabad, the Supreme Court has clearly underlined the distinction between an agent and servant. The main important point is that agent or has the authority to act on behalf of the principal and to create an contractual relations between the principal and a third party. This kind of power is not given to a servant or an employee. A master is liable for his wrongful act of his servant if it is committed in the course of servant's employment. A principal is liable for his act wrong done by the scope of the authority. In this case, whatever Professor Muskan was guiding, it was not in the scope of her employment. So, as per this judgment, there is no agency in the guidance process of the Professor Muskan. And the last argument the council would like to prepare. And there are also further cases which I couldn't found, but I have given a reference from this book. In this, the MD of a company is an employee. It is also in a position of agent because position of an agent. Similarly, the secretary is also an employee. He also acts in a capacity of agent because it represents the agent and is dealing with the third person. Professional advisors such as stockbrokers and often act as a client. Other professional persons are engaged simply to produce a specific result. For example, to prepare a report, to paint a picture. Such persons have no power to act on behalf of their clients.
So you are saying that Muskan was engaged for a specified result.
To teach the students to get their better education. These are the employment. These are the terms of employment as a teacher. No, but as a professor, generally these are the responsibilities that is given to a professor.
That's an
In general balance, this is the generality that's happening. Yes. No.
Absolutely.
But there are lots of teachers here, and every teacher has some different responsibilities. Like you, Muskan ma'am, Vikas sir, there you have different responsibilities. All of the teachers don't have a similar responsibility.
Okay.
Uh, on this, my last argument is on the second issue, that whether allocation agreement is altered by the effect of correspondence between the appellant and the Professor Muskan. In the case of Sangyong Engineering versus Contract Company Limited versus NHAI, the Supreme Court had held that that it is against the fundamental principle of justice that a unilateral decision, addition or alteration of a contract is forced on an unwilling party. And if we look on the last point of the agreement signed between the appellant and the respondent, it is clearly stated that any material changes can only be made by the valid consent of the parties of the contract, which is the college and the Vikas.
She comes under the college only, no? Professor Muskan.
But she doesn't have. But in his, the dean has clearly stated any type of negotiations and business plan would be directly would be done with the management of the board.
It has also been stated in that agreement, if you could go to the second paragraph, that participants will be given lots which are to be later allotted to them based on a request made by them. Now, if we go through again the series of the events, the participants are required to negotiate with the board. So when I say you have to make a request for allotment of the lots, whom are you going to make the request? To the board, because board has the power to do everything, right? In the instant case, Vikas made a request to whom?
Professor Muskan.
Did he get the lots he requested?
Yes, he gets an acknowledgement.
So basically, as per the agreement, he went to Muskan, made a request over there. The agreement says you have to make a request to the board. So by connecting the dots, we can understand that the college is by its conduct, if not express, showing that Muskan was an agent. She was a part of the board because the request that was made to Muskan was ultimately approved. The college should have simply said that if Muskan was not an agent, the college could have told Vikas to just simply come to them, right? So I think your conduct, if you're saying that Muskan was not expressly your agent in this matter, I think by your conduct, she is an implied agent now.
I understand your consideration. I understand your consideration, your lordship, but I beg to differ because he asked for an acknowledgement, not he requested. He has asked for acknowledgement that he wanted to give to the trucks, the business owners, the vendors. It is not clearly stated anywhere that he was asking for the slot size, the lot numbers, and in the uh, in the email on the 14th April 2024, he said, the preparation for the meetup are going very well. I have completed all the procedures mandated by the college to their notifications. So college has given a notification which could include the allotments list that could be the in the email on 14th April 2024. He stated the preparation for meetup are going very well. I have completed all procedures mandated by the college through their notification. Here a college had given a notification which could which have all the procedures and which could also include the lot numbers to the allotted to the specific participants. And alteration cannot be done without a proposal and an offer. In this email, he said, I will vacate the lots a day after the end of the meetup. It's not proposal. He's telling that he will vacate. So we can assume, we can conclude.
Very much equal to proposal, na?
Yes, ma'am. Pardon your lord ladyship.
Same as proposal.
But it is a tone.
He is requesting,
But he could also say, please let me know in a terms of a guidance that whether I am doing all the things in a correct way.
That is something that you're assuming, na?
That's my point.
Even if Muskan had said no, don't do it, what would he do?
He would ask for further guidance, further help from them. That
I don't think this point stands valid, honestly, counsel. I'm not convinced at all. Your other points I might accept, but this point, it's very clearly, it is very evident that he's telling her that I wish to do this. Please let me know if you have a problem.
the council would like to move on the prayer. Sorry, Your Lordship. All these things only indicate that the student is seeking a guidance from a mentor and nothing more than that. And there is no communication of any alteration happened between the appellant and the Professor Muskan. Hence, Professor Muskan is not an agent. If she is not an agent, she can't do an alteration on behalf of the college.
What's your prayer?
In the light of facts stated, issued raised, arguments advanced, and authority cited, it is humbly prayed before the Honorable Court to adjudge and declare that the Professor Muskan was not an agent of the Global Business College. Allocation agreement is not altered by the effect of correspondence between the appellant and Professor Muskan. Order the appellant to compensate the defendant for the legal charges rupees 10,000 which he has incurred during this whole process, and an advocate fee that he is paid rupees 1 lakh rupees, and pass any other order the court may deem fit in the interest of justice.
You have charged 1 lakh rupees.
This is a business college, right? And what logic is this business wise that in order to recover 30,000, they have paid 1 lakh to you? Are you trying to loot them or something?
It's a standard fees that we usually charge. That's a,
You charged 1 lakh rupees to recover 30,000.
it's not about just 30,000. It's about his value of words that he made in front of all the participants and even the clientele which he has, whom it has been a loss.
Okay.
You're done? What are the parties in a case called as? How do you refer them?
Appellant and the respondent.
Appellant and?
The respondent.
Can you please refer to the first page of your memo?
I'm really sorry, Your Ladyship.
And that's fine. Thank you. I am your fellow judge. Speak properly. अपन क्लास में टोटल बच्चे कितने हैं? 20 है ना? 20 terrible. You decide. One marking number 20 terrible. Terrible? Terrible? I want to see it. 21 and I have 22. है? हाँ, कौन क्या है? वो तो अपनी नीड है ना, वो blind. Okay, sir. थप्पड़ मार देंगे. No, ma'am. You're sorry. Yes. Yes, yes, yes. हो गया? चलो. No, ma'am. हम जल्दी ब्रेक होगा. अरे सीधा मुझे कॉन्ट्रैक्ट करता रहेगा. अच्छा, 3 ही तो है कॉन्ट्रैक्ट में बचे हुए. तो अपन जिस तरीके से डील कर रहे हैं, एक ही बच्चा जाके गलत हो रहा है. इतना तो छोड़ो कि क्या बीमारी का डजन केयर. तो हुई. फिर हुई. हाँ. फिर आशिक हो गया. अब बताओ मैं किस जगह पे. अरे नहीं, मैं बोला ना श्री कि रोई पहली बार बाहर जाके. और इतने दिल कर ही नहीं रहा यार इस बार. बट वैसे तुम लोग को पता है बाबू खाना आयुष सीखना चाहिए. कल आयुष क्लास में हम कुछ सीख रहे थे. वो ऐसे अरे ये क्या हुआ? सर अरे उसका कंपनी वाली अरे ये है बाबा, ये है रोल. एक बार वापस बंद करो. आयुष को बता. आयुष बता कैसे करते हैं.
हेलो.
सर भूल गए ना.
एक सेकंड. Yes, counsel. Start.
Am I audible? If it may please the Honorable High Court, this is Counsel Mehak Jamnani appearing on behalf of Mr. Vikas Shukla, the appellant in the case of Mr. Vikas Shukla versus Global Business College. The Counsel seek permission to address this Honorable Bench as your Lordships.
If my fellow judge don't have any problem, I would like the bench to be addressed as your ladyship. Do you have a problem? No. You have a problem? Never. Ladyships.
If your Ladyships may permit, this Counsel would like to present the facts of the case.
We don't want any facts. We are well aware of the facts. Move ahead with your arguments. We'll not cut marks for this. We'll see how well you use your facts in the arguments.
If your Ladyships may permit, Counsel would like to move on to the issues of the case. Proceed. Whether Professor Muskan was acting in the capacity of an agent of the respondent while corresponding with the appellant, whether allocation agreement is altered by the effect of correspondence between the appellant and Professor Muskan. If your Lordship may permit, if your Ladyships may permit, Counsel would like to move on to the arguments of the case. First argument, whether Professor Muskan was acting in the capacity of an agent of the respondent while corresponding with the appellant. As per Section 186 of the Indian Contract Act 1872, the authority of an agent may be express or implied. As per Section 187 of the Indian Contract Act, an authority is said to be implied when it is to be inferred from the circumstances of the case, things spoken or written, or in the ordinary course of dealing may be accounted circumstances of the case. As per Section 237, when an agent without authority done acts or incurred obligations to third party on behalf of his principal, the principal is bound by such acts or obligation if he has, by his words or conduct, induced third person to believe such acts or obligations were within the scope of the agent's authority. In the instant case, Professor Muskan, the head of the Department of Human Resource Study, through her position in the college, which was given by the college, and also through her communications via email, reasonably led Vikas to believe that she was the agent of the college and was acting on behalf of the college to help organize the meetup. Professor Muskan had specifically asked Mr. Vikas to send her the business blueprints along with the financial details by email only, whereas if she want the agent would if
She
want
asked
the
because your client approached.
Yes, but she could have denied. She could have said only send the blueprints or given.
But the college
certain
made it
advance.
appropriate, मतलब ऐसे apparently clear, right? That anything and every communication is supposed to be made with the board.
Yes, but she could have denied or she could have said, okay.
But college made it evidently clear that you are supposed to communicate to the board.
Your Ladyship, I understand, but she was inducing herself as she was the agent through this email. She could have just given advice over.
I believe that she's just helping a student out. That's it.
But it could have been through normal. She
What
could
is
have not
normal?
said normal conversation.
It is a normal conversation.
But she could have said without. She could have denied. She could have not asked via email.
So the mistake is this.
No, but she formally asked him.
So the mistake is Muskan's, right?
Yes.
So why is your client coming after the college? It's fine. Let the college deduct 30,000 and you file a case against Muskan because she made you believe that she was an agent.
But it is not liability of Vikas to file a case against Professor Muskan. It is college who should file a case against her if they have incurred certain loss because of her acts.
Okay.
The most integral part of the agreement being the profit sharing ratio, which was finalized after Vikas has discussed it with Professor Muskan and asked for her confirmation of Professor Muskan in the email dated 30th April 2024. The subject of the email being proposal of profit sharing
Counsel, your client got the allocation agreement done on 15th of February 2024.
Yes.
Right? With the management board.
Yes.
Then he is communicating to Muskan with Muskan on 30th of March. So your client knew that he is supposed to communicate with the management board, right?
Yes.
Why is he even approaching to Muskan when the allocation agreement is already done?
because the allocation was done was not made on behalf of all the members. It was given from a designated member of the board. So Vikas believed that Professor Muskan was the one.
Okay.
Vikas had also in the email dated 14th April 2024 asked Professor Muskan for any recommendation with regards to profit sharing ratio between Vikas and the college. Professor Muskan had not once intimated or represented that she was not in fact the agent of the college. Vikas also received the acknowledgement letter bearing the official seal and stamp of the college only after his communications with Professor Muskan, which further led him to believe that her authority in the capacity of agent towards the college. Hence, she would be held as the agent of the college. The allocation agreement clearly states that the lots on the premises shall be allotted later on the basis of the request made by the participants. Vikas had only mentioned his wish to avail lots number 12, 13 and 14 to Professor Muskan via email dated 30th March 2024, which depicts that Professor Muskan had communicated to college about her communications with Vikas. Mr. Vikas had repeatedly asked for her assent of Professor Muskan before conducting any work or operations of the meetup. Firstly, in the email dated 30th March with regards to his plan as well as the profit sharing ratio. Secondly, he began the preparations for setting up the meetup only after his communication and receipt of assent of Professor Muskan. Thirdly, in the second email by Vikas dated 14th April 2024, he asked her approval upon the menu for the food trucks. To all these acts, Professor Muskan had, if your ladyships may permit, council would like a further extension of time. To all these facts, Professor Muskan had not once denied her authority with respect to the meetup or its organization. In fact, she had replied to all these emails and approvals in a positive manner and asked him to contact her if any further assistance is required from our end. In reply of Vikas's email of confirming about vacation of lots, Professor
Council,
Muskan,
let's keep it very simple. Tell me the ingredients. If this exists, there can be implied agency, and the ingredients are fulfilled in this case. That's it. And the case is yours.
she made Vikas believe that she had the agency because of her positive response via email that lots wish to avail the lots, which was only communicated to Professor Muskan and not to college itself. And she also gave her assent to the alterations. And she asked for the blueprints of the meetup, which all these indicate that she had the authority. But the college, after the college incurred loss, the college mentioned that she was not the agent or authorized, but this was not done prior any prior email, even though Professor Muskan had communicated all of this to college. Shall I continue? Second, whether allocation agreement is altered by effect of correspondence between appellant and Professor Muskan. As per Section 8 of Indian Contracts Act 1872, performance of contract of a proposal or acceptance of any consideration of a reciprocal promise which may be offered with a proposal is an acceptance of the proposal. Through the manner of communications, Professor Muskan via email to Vikas.
Can you, this agreement was a physical agreement? This allocation agreement, because he signed it in the office, right? And then you're claiming that the alteration was done via an email.
Yes.
Can you alter a physical contract by an e-contract?
Yes, because e-contracts are also valid.
Where is it written?
In the Indian Information Technology Act, Section 10A.
Okay. Section 10? Okay, proceed.
Section 62 of the Indian Contract
Council,
Act.
wind up your argument in 2 minutes.
The doctrine of promissory estoppel prevents a person from taking a position that is contrary from the previous one, which may harm the other party. It prevents someone from going back on their words in a court of law, and hence this doctrine would hold the principal liable for the acts of the agent, that is, the college for the acts of Professor Muskan.
What is the concept of promissory estoppel? The concept of promissory estoppel? You
It
just mentioned.
It just binds the principal for the acts of the agents, even if no express authority has been given.
Okay.
By not objecting to Vikas's proposal and instead sending a positive response, college through email led Vikas believe that extension was approved. Based on this belief, Vikas acted by not vacating the lots on the stipulated date, and college during such period had not once communicated or clarified that the Professor Muskan was not the authority, and hence the college should be stopped from denying the validity of the altered terms. As well as it was the duty of the organizer of the meetup, that is the college, to ensure that after the end of the meetup, the premises which were distributed in lots had been vacated by all the participants, which shows clear negligence on their part. It was the duty to confirm that all the lots had been vacated by the end of.
Counsel, a physical contract is required to be signed physically.
Yes.
Vis-a-vis, an electronic contract is to be signed digitally.
Yes.
But this was not signed digitally. You still consider that as a...
But it has also not been mentioned that it was not signed. It is.
That's the requirement of law.
Yes.
That's not the case which decides whether a contract not digitally signed is yet a valid contract.
But even if this was a negligence on part of Vikas, the contract cannot be merely just cancelled because of signing.
So that renders the contract invalid prima facie.
Yes, but this can be later ratified.
But there's no act of ratification which is given.
This can be done now also after all the disputes have been made.
So when you are arguing this matter before the court, after this ratification can be done?
If they settle on those terms.
If they?
If they settle on this. If both the parties agree, the college can agree to it.
No.
But
What I'm saying is that a valid alteration to the contract which is not electronically signed?
no, it is not.
It is not. So what are your arguments based upon if the contract itself is invalid?
But the alteration was made via email, so sorry, I do not have answer to that. If your lordship may permit, the council would like to move on to the prayer of the case.
Don't you have any case laws to cite?
Yes, I do. They are given at the back.
Acha, irrelevant for your arguments.
In the case Chairman, Life Insurance Corporation versus Ravich Kumar Bhaskar, this case said that it was settled that for the purpose of determining the legal nature of the relationship, the use of or omission of the word agent is not a conclusive. And it also defines Section 182 of the Indian Contract Act.
Okay.
And the second case, which is Motilal
Padampat.
Padampat Sugar Mills Company versus State of Uttar Pradesh and others. This case talks about the doctrine of promissory estoppels, wherein the principal shall be held liable for the acts of the agent.
किसका है? High Court, Supreme Court? Life Insurance Corporation?
Supreme Court.
Liga.
Okay.
If your ladyships may permit, counsel would like to move on to the prayer of the case. In light of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before the Honorable Court to grant Vikas, the appellant, relief by way of reimbursement of the deposit deducted by the college, that is rupees 30,000, and all the legal costs that were incurred to refer this matter to the Honorable High Court and pass any other order that the court may deem fit in the interest of justice.
Cost? Do you want the bench to calculate the legal cost?
Yes.
We will calculate the legal cost.
The legal cost would include the fees of that the client has paid to me.
So that
along
is something that you will tell us, no? What is the legal cost exactly that you want?
But this may vary case to case. It depends
So
upon
what is the amount that you want in your case?
2 lakh rupees.
And how do you calculate that?
By fees along with the application fees for the appeal.
What's your fees exactly, if you don't mind?
1.5 lakhs.
1.5 lakh for one hearing.
Yes.
Okay. ठीक है. Thank you.
If it may please your Honorable High Court, this is Counsel Rajas Mehta arguing on behalf of the respondent in the case of Mr. Vikas Shukla versus Global Business College. Counsel seeks permission to address this honorable bench of High Court as your lordships collectively.
Your ladyship.
Yes. Yes, your ladyship.
Your lordship and your ladyship.
Yes.
Thank you.
If your lordship may permit, counsel would like to state a few facts of the case. There are a few crucial facts which I want to. Okay. If your lordship may permit, counsel would like to mention the issues raised. The first issue raised is whether Professor Muskan was acting in the capacity of agent of the respondent while corresponding with the applicant. And the second issue raised here is whether the allocation agreement is altered by effect of correspondence between applicant, appellant, and Professor Muskan. If your lordship may permit, if your ladyship may permit, counsel would like to advance the arguments.
Proceed.
The first argument advanced by the respondent side is Dean of the college in his speech clearly mentioned that all participants must conduct their business activities only with the approval of the board. Whereas there is a clear breach of contract by the appellant, who is Mr. Vikas Shukla, as he did not fulfill the terms and conditions of the contract, and there is a clear negligence on the part of appellant interacting with Ms. Muskan and trying to alter the allocation agreement.
Counsel, will the dean's announcement prevail over the allocation agreement?
No, your lordship, it won't prevail over the allocation.
So in the allocation agreement, point 6 says, any material change or alteration has to be done with the valid consent of the parties.
Yes, your lordship.
Okay. Nowhere in the allocation agreement is there mention of any board.
Yes, definitely, your lordship. There is nowhere mentioned that the party should be the board. But when there was a designated member who was already assigned to Mr. Vikas Shukla, it is responsibility of Mr. Vikas Shukla to co-relate with him and provide the update of the details and alter the agreement with the board.
And isn't it
Not-
the responsibility of the college to let him know that if he is corresponding with the wrong person, that the wrong person does not have that authority?
I beg your pardon, Lordship.
So when he was corresponding with Muskan, the college knew about it.
College didn't knew about it when he was corresponding with Ms. Muskan. The college knew about the fact that he would correspond with Ms. Muskan or some other professor of the college till the extent of the profit sharing ratio and allotting the lots to them. But the college didn't knew about the alteration of the agreement. Alteration of the agreement with Professor Muskan.
So you're
and
saying
Vikas Shukla.
Muskan had the authority to talk about profit sharing and allocation of lots, but not the authority to alter anything
Yes,
else.
Your Lordship, it can be said. Okay. If Your Lordship may permit, Council would like to advance the next argument.
Okay.
Whether Ms. Muskan had an authority. Ms. Muskan was not acting in her official capacity as an agent of the board of Global Business School in the communication with the appellant. As per the facts of the case, appellant without even thinking twice. I would mention the line without even thinking twice. Your Lordship, one may, when someone reaches the board, someone cannot, without even thinking twice, reach the board. As a board is authority, and one would think more than twice reaching the board. So this is clearly an informal communication and not a formal one. Appellant would not have acted in such a manner if he were interacting with a designated member of the management board.
आप एक बार twice वाला वापस बताओ.
With the, yes, Your Ladyship, appellant, who is Mr. Vikas Shukla, without even thinking twice, reached Miss Muskan. So it was a clear informal relationship, as it was without even thinking twice.
ठीक है. हाँ ठीक है. Okay.
Okay. Professor Muskan's role as head of HR studies does not inherently imply to alter or amend any contractual agreements on behalf of the board of respondent. Also, as per section 182 of Indian Contract Act, an agent is someone who is authorized to act on the behalf of another and bind them through their actions. To be considered an agent, there must be clear delegation of authority. I would like to mention a case here, State Bank of India versus SN Goel, where the Supreme Court had held that the scope of agent's authority must be clearly established and that the acts beyond this authority are not binding on the principal. The next argument.
Counsel, what about there's a section in the Contracts Act which is section 237, which states that when an agent does any act, even if it is beyond her scope of authority, and if the agent makes the third party believe that she has authority to do that, the principal would nevertheless be bound by it.
But the authority, till the extent, should be Mr. Vikas Shukla already knew of her authority, and he did not know that.
No, okay. Let's say even without thinking twice, he went to her and he just went there informally, right? Wasn't it Muskan who asked for the financial ratios?
Yes, it was.
Why did she ask for the financial ratios if she didn't have the
financial ratios? As Mr. Vikas Shukla needed the assistance of Professor Muskan. It is an informal communication which is taking place here, where if I give an example here, if my favorite professor is Mr. Chirag Chotrani.
हमको लगा था मेरा नाम लेगा सबसे ज़्यादा सब्जेक्ट्स पढ़ाते हैं.
But three of the names are already mentioned here, so I chose to.
Okay.
So if if your ladyship may permit, council would like to extend some time. So if my favorite professor is Mr. Chirag Chotrani, I would definitely reach out to him without even thinking twice. And if the board member is Mr. Vikas Vora, I won't go to him directly. I would approach Mr. Chirag Chotrani instead of approaching Mr. Vikas Vora directly and ask for the help of Mr. Chirag Chotrani in assisting me in some things. So,
Let's come to point 5. Do you have a fact sheet? Do you have the fact sheet?
I have the fact sheet.
Yeah.
Yes.
There are 3 points in this email itself, which are a little, against your argument, if I may. Number 1 is the subject. Very clearly, this guy has written in the subject that it is a proposal of profit sharing. Okay? Then, when you see next page, first line, this person says that I wish to avail lots number 12, 13, 14, which again he was given. Next, he says, profit sharing may be based on 60-40 model, where college take 40% of profit. Kindly confirm the same. So he's seeking approval.
Yes, Your Lordship.
And in the next point, that is point 6, second last line, it says, after receiving her assent, Vikas made necessary preparations. So even though Vikas went to her without thinking twice, Muskan, when he asked for Muskan's assent, never said that I do not have the authority to give the assent. In fact, she gave her assent, after which Vikas started preparing.
Yes, Your Lordship, I definitely agree to that. But if we also see the point number 2, the last line says the interested student should negotiate with the college regarding the profit sharing ratios and sign
That
an
is what the
allocation
dean
agreement.
said, right? But the allocation agreement does not talk about the board. So we will not consider board important. The
Okay.
only question over here now is, when Muskan was acting, was she acting in the capacity of an agent?
She was acting in capacity of a general agent, where it is mentioned that she did not have the specific authority. She did not have the specific authority to alter an agreement, as alteration of an agreement is not a non-material change.
Is there a difference between a general agent and a special agent?
Yes, there is a difference between general agent and a specific agent. In case of specific agent, all the documentations are necessarily made
Certainly.
and prepared. And in case of general agent, the authority is implied, but it is not clear what the authority actually says,
Okay.
and it limits the scope of the agent.
So is general agent also an agent?
Yes,
He's an agent.
yes, Your Lordship.
Which means Muskan, as you stated, is a general agent. So she happens to be an agent.
Yes, but her authority extended till the allocation of the lots and profit sharing ratio to be
Okay.
negotiated, not to alter the allocation agreement.
So what is this counter? But
Gen-
that's nowhere stated that the scope of agency was restricted to allocation of counters or maybe the PSR. That's what you're inferring from the facts.
It is nowhere stated, but it is also nowhere stated that that she had the authority to alter the allocation agreement.
Exactly.
Yes, I'll come to that again.
Also, the email says, I'm on board with you,
I,
which,
Your Lordship, it is a very vague reply and it is not clear expression. If we see the fact sheets on the point number 4, point number 6, it says that Vikas received a letter of acknowledgement bearing the official seal and stamp of the college.
correct.
Okay. It was very important to give official seal and stamp of the college on acknowledgement itself, whereas the allocation of agreement is even more material change, which definitely required a writing practice and also official seal and stamp of the college, which is nowhere mentioned in the fact sheet.
Email is a good enough validation.
I would like to advance my next argument regarding to this. First of all, Your Lordship, this was not clear. It was very vague. I'm on board with you does not mean that you can change, you can alter the allocation agreement, and the date has been shifted from 25th April to 26th April. Also,
The same email also states from our end. When you use the word our end instead of my end, are you not referring to the institute and not herself?
Your Lordship, if we see again the fact of point number 7, I have completed all the procedures mandated by the college through the notifications. I have already engaged in food trucks and confirmed the menu to suit the target audience at the meetup. I hope you approve the same. The email here had been in two parts. The first part being this one, and the second part was due to logistics issue. I will vacate my lots a day after the end of the meetup on 26th April. So in reference to the update on the preparation, Ms. Muskan replied that, thank you for the update. I understand and I'm on board with you.
Right.
As he has already notified the college separately and not just Ms. Muskan. He should have notified college about the allocation agreement alteration. Also, Ms. Muskan stated, do let me know if further assistance is required from our end.
Right.
Our end is regarding the first part of the email and not the second part of the email, where this is, whenever there is a clear alteration, both the parties need to be clear and not, there is unequivocal promise. The respondent could contain that the communications from Professor Muskan do not clearly state a clear and unequivocal promise. Appellant's reliance on these communications was neither reasonable or justified. Also, in the case of Motilal Padampat Sugar Mills versus State of Uttar Pradesh, the Supreme Court of India contended that the promise must be clear, unequivocal, and intended to create legal relations. So there are no legal relations created through this.
Counsel, if we refer to these words called please let me know, is this an intimation or a permission?
Please let me know. Is
Are
it
you trying to intimate or are you trying to take permission?
Please let me know is permission.
It's
Your-
seeking permission.
Yes.
The email follows. It says, thank you for the update. I understand and I'm on board with you. So someone has sent a proposal. The other person has agreed. When they've agreed, obviously she happens to be the office bearer, HOD. So she possibly has every right to do that.
I would like to state another argument regarding this.
Yes.
Even if we believe that she was authorized to do that, there is Article 30A of Schedule 1 of Bombay Stamp Act, which says, which is regarding levy of stamp duty on leave and license agreements. Okay, and the parties to the contract, appellant and respondent, have entered into a valid contract on the date on February, right? They must have paid the stamp duty at the time of executing the allocation agreement. That is on 15th February 2024. This is also stated in the case of Empire Industries Limited versus Chief Controlling Revenue Authority. Now, as per Section 14A of Maharashtra Stamp Act, where due to material alterations made in an instrument by a party with or without consent of other parties, the character of the instrument is materially and substantially altered, then such instrument shall require fresh stamp paper according to its altered character. Here, the material alteration document was neither stamped by the appellant, nor stamped by respondent, nor by Professor Muskan. This also makes the said alteration by email inadmissible in the Court of Justice. This was said in... Yes.
Answer. Stamp duty was paid on the original agreement.
Yes.
Right? What
Yes,
terms were altered does not change the character of the instrument.
Yes,
It
Your
still
Lordship.
remains a leave and license agreement.
Yes, Your Lordship.
There was no change in the fee. So
Yes, Your Lordship.
since there is no change in consideration, although it qualifies to be an instrument, the
Yes,
value
Your
of stamp duty would not change. So any subsequent alterations can be done on a plain paper also. And why are we considering Maharashtra Stamp Act? I mean, is this a case which is of Maharashtra? Matlab, somewhere the jurisdiction is given?
Yes, yes, Your Lordship.
It's at Pune. Okay,
Yes,
fair
Your
enough.
Lordship. Even in the case of State of Maharashtra versus National Organic Chemicals Limited Industries, wherever there are material alterations, such instruments shall require a fresh stamp paper. The Supreme Court of India stated that.
I appreciate that. But
Yes, Your
when you refer to the material alterations,
Yes, Your Lordship.
on what amount do you pay the stamp duty?
On the amount which has been agreed on
part of the agreement?
rent
Which is a lakh rupees deposit?
yes, yes, Your Lordship.
And apart from that, whatever the rentals are. Is there any change in the deposit or the rental amount?
So there can, Your Lordship, there can be a change in the deposit of the amount because
That's nowhere stated.
even if there is a change after a day, the days are mentioned here from 20. The
Days would not alter the value of stamp required.
Yes, Your Lordship. I would like to again argue on the point
Yes.
where there were not clear and unequivocal promises. Also, I would state that if Miss Muskan can provide him official seal and stamp of the college in the place where there was just the lots decided and profit sharing ratios are decided, she has definitely the authority to give official seal and stamp in
She is an agent.
seal and stamp. But she did not give the same during the alteration of the agreement. If so, this
Yeah.
is very sometimes letter of acknowledgement was bearing the seal and stamp. Even sir, Your Lordship, the alteration of agreement, which is material. Material is if we refer to the allocation agreement, point number 1, it says the leave and license shall commence from the date of 20th April 2024 and shall remain effective for a period till 25th April 2024. This is a material change in the alteration agreement. This email is very unclear and vague.
Yeah, absolutely. I at the first place did not even understand what is the first part of the email and second part. Okay. Nowhere stated. It's replied in general.
There is a difference between providing letter of acknowledgement and altering the allocation agreement.
My friend, it is absolutely acceptable if it is done via email. There's no law which restricts or perhaps prohibits the scope of an email. Yeah, completely substantial.
But Your Lordship, these are material changes. Material changes need to be documented. Why was the first part of
Email
the
is not valid document.
email is a valid document, but it is very unclear. Material things are stated very clearly from the both parties of end. Yes, Your Ladyship. Unclear is Professor Muskan's reply, which is thank you for the update. I understand and I am on board with you. Do let me know if any further assistance is required from our end. Best of luck. So this is very unclear as about the logistics issue, which Mr. Vikas Shukla has.
She says I am on board, na?
Yeah. So she,
it doesn't-
instead of this, she should have copied the first point. Uske aage she should have written yes, agreed. Second point, agreed. Like
Yes,
that.
I agree with you, Lordship.
This is how it should have been replied.
She shouldn't have replied this way, but she should have replied, definitely, you can vacate the lots a day after the end of the meetup. That is 26th April 2024. This would have been a clear communication and then it would have been effective.
Yeah.
So, Your Lordship, this is very informal communication. I already mentioned without even thinking twice.
I think there is a judgment in criminal law, no? Rape wala. A no is an answer also. So, yeah, absolutely. Yes is an affirmation. Yeah.
Your Lordship, but even the Supreme Court says that whenever there is material alteration to an agreement, there should be clear and unequivocal promise, unequivocal and intended to create legal relations. This does not create any legal relation here. This is very vague reply, and on the basis of the vague reply, this is
Okay, my friend, just one last question.
yes, Your Lordship.
I'm seeking permission from you. I'll say, can I touch you? Okay. In reply, you say no. Again, I'll say, can I touch you? You say, no, you cannot touch me. Is there a difference between the two?
Yes, there's a difference between
There is a
the two.
difference.
Yes.
Do not say, I've added 4 more words. Apart from that,
No, the tone of the conversation. You
I
said
think
no.
equally loud and clear.
If it was equally loud and clear, it does not make any
There
difference.
is no
between-
difference.
Yes.
I think you're arguing upon the same thing, that there is a difference.
Okay, Your Lordship, I'll come to the
Fair.
argument again. One more argument.
Counsel, you have 1 more minute to wind up your next argument.
My next argument is whether the alleged alteration to the allocation agreement was valid. The communicate I already stated as it did not constitute a valid alteration agreement. In the present case, appellant's email with Professor Muskan was not formalized by written agreement from the college authorized signatories. As such, the extension of the occupancy period was not officially approved. This was even stated in the case of Nathulal versus Fulchand, Suresh Kumar Vadhwa versus State of Madhya Pradesh, Satyapal Anand versus State of Madhya Pradesh and others. The Supreme Court stated that the court ruled that the terms of contract could only be modified with the mutual consent of both the parties. Also, if we look at the allocation agreement and clause 5 of the allocation agreement, which says the participant shall cease to use and occupy the licensed premises and hand over the licensed premises without demur, protest or objection to organizer by the end of 25th April. Mr. Vikas Shukla did not hand over the lots of the.
That
lots
is what they
allotted.
amended and altered, na? That is the exact clause which they amended and altered.
Your Lordship, I feel the email was very vague according to this point.
Do feelings work in courts of law?
Even the Supreme Court felt that, Your Lordship, even the Supreme Court stated that. I beg that.
Which case?
Motilal Padampat versus Sugar Mills Company Limited versus State of Uttar Pradesh. The Supreme Court, the promise must be clear, unequivocal, and intended to create a legal relation. I would state.
You're saying these 3 requirements are not there in
Yes.
the instant case.
It is not clear at all. It is very vague.
Okay.
And Ms. Muskan did not have the authority to
No,
alter
you
the
have agreed
agreement.
that she was an agent.
I agreed that she was an agent, but she was a general agent. It should have
Even
been
if a general
specific
agent, if a general agent, section 237 of Indian Contracts Act is very clear on it, that if there is an agent and if that agent increases or goes beyond the scope that has been authorized to them, but the third party with which the transaction has happened is made to believe that she has that authority, then the liability lies on the principal. Here, if you have agreed that she is an agent, undoubtedly she might have gone beyond the scope of authority given to her. But if Vikas was honestly made to believe that she had that authority, the liability lies on the college. So, since you have accepted that she is an agent,
Your Lordship, I accepted as general agent. You
Agent.
mentioned that same thing.
yeah, general agent, but then section
But there
237
should be
application.
specific authority provided to Ms. Muskan in case of alteration of allocation agreement.
Because it's material.
It was signed with the college, but it was already said that it was signed with the designated member of the board. And a copy was provided by the designated member of the board. So it is the designated member of the board or the management board of the college itself who has the authority to alter the allocation agreement and not Ms. Muskan.
Move on to the prayer.
Yes, Your Ladyship. In the lights of the facts stated, issues raised, arguments advanced, and authorities cited, that this Honorable High Court may be pleased to uphold the findings of the Honorable District Court of Pune and dismiss the appeal. Much obliged, Your Honor.
This is our last speaker for contracts. She's. After this, we'll take a break for our lunch, and then we'll continue with the crimes wala case. Okay, counsel, you may start. एक दाल खिचड़ी आ रहा है, एक आलू पराठा आ रहा है, एक चीज चिली टोस्ट कर देते हैं। मेरा तेरा विशिष्ट
मैम
वैसे ही होता है उसको।
trousers. Good afternoon, bench.
Yes.
Shall I proceed?
Start.
If it may please this honorable court, this is Counsel Anushka Chaudhary appearing on behalf of plaintiff Vikas Shukla in the case of Mr. Vikas Shukla versus Global Business College. The counsel for the appellants hereby submit to this honorable court that the petitioner has approached this court under section 96 of the Civil Procedure Code 1908, which provides the honorable court jurisdiction to entertain appeals from the decisions of civil court. The appellant would like to humbly submit that this appeal is maintainable. If this honorable court may permit, the counsel would like to submit to the bench a memorandum of the case. If the honorable court may permit, the counsel would like to state the facts of the case.
If the facts go on to the issues, we know the facts, we'll not cut your mouth. Use the facts in your, you're using your facts in your argument.
Yes.
All 20 marks given.
If this honorable court may permit, the counsel would like to state the issues of the case. The first issue is whether Professor Muskan was acting in capacity of an agent of the respondent while corresponding with the appellant. The second issue being whether the allocation agreement is altered by the effect of correspondence between the appellant, Professor, and Professor Muskan. If this honorable court may permit, the counsel would like to proceed towards the arguments of the case. Professor Muskan, in response to my client's email dated 30th March 2024, provided letter of acknowledgement bearing official seal and stamp of the college, inducing my client to believe that she had the authority to act on behalf of the college, which the college further now denies. No, I'm fine. Thank you. It is humbly submitted before this honorable court that Professor Muskan was acting in capacity of the agent, and there exists a principal-agent relationship between the Global Business College and Professor Muskan. In Shakti Sugars Limited versus Union of India, it was stated when the existence of an agency relationship would help decide an individual problem and the facts permit the court to conclude that such relationship existed at a material time. The court stated whether or not any express or implied consent to the creation of an agency may have been given by one party to another, the court would be entitled to conclude that relationship was in existence at the time and for the purpose in question.
Counsel, what court is this? किस कोर्ट ने जजमेंट दिया है?
This is High Court.
Which High Court?
Just a second.
Assam High Court.
Okay.
Further, in Chairman Life Insurance Corporation versus Rajiv Kumar Bhaskar, the court stated that it was well settled for the purpose of determining the legal nature of relationship between the alleged principal and agent. The use of or omission of the word agent was not conclusive. If an employer has a reason to believe that his employer was acting on behalf of the corporation, a contract of agency might be inferred. In this case also, my client has believed on Professor Muskan's conduct and relied on her behavior, inducing him to believe that she was an agent of the school.
What behavior can you please point out 2 to 3 behavior of Muskan that made Vikas believe? Can you please point out 2 to 3 instances which made Vikas believe that Muskan was the agent?
When my client first communicated with Professor Muskan regarding the profit sharing ratio and allotment of lots, she provided him with a letter of acknowledgement bearing the official seal and stamp of the college, and she made him believe that she had the authority.
That is one instance.
And secondly, when my client communicated with her regarding the alteration, she stated that I understand and I'm on board with you. Do let me know if any further assistance is required from our end.
All right.
If the Honorable Court may permit, the Council would like to proceed towards the second issue of the case.
Okay.
The second issue questions the alteration of allocation agreement by effect of correspondence between Appellant and Professor Muskan. It is humbly submitted before the Honorable Court that the allocation agreement was altered by Professor Muskan, that there was an email made for such alteration, that the respondent has served a statement via their representative, Professor Muskan, and there was an extent of implied authority.
How was the original agreement made physically?
Yes.
And the alteration that you are claiming to be there is via emails? The alteration or whatever discussion they had was via emails?
Yes.
Can an email alter a physical contract?
There was a consent between the parties to the contract.
All of that is there. But can an email in the first place alter a physical contract?
The Council believes that the alteration is valid.
Okay.
Professor Muskan, in response to my client's request of alteration of contract, has approved the same. Section 188 of the Indian Contract Act states that an agent has the authority to do every lawful thing necessary for conducting the business. Implied authority might not have been conferred by express words, but can be inferred from the circumstances of the case.
And what if the agent exceeds the authority?
If the agent exceeds the authority, the principal might not be liable, but if the principal subsequently ratifies the same, the principal should be liable. In the House of Lords versus Amargas Limited versus Mundagas SA, it was stated that if a person has entered into a contract with an agent on reliance of that representation, ostensible authority may also arise when the agent had a course of dealing with a particular contractor and the principal has accepted this course of dealing and honored the transactions arising out of it. Initially, the actions of Professor Muskan might have been beyond her authority as an agent, but the conduct of school subsequently allowing my client to be a part of the meetup, accepting the profits arising out of it, ratifies all such acts.
The 2 acts we're talking about are allotting the lots and ratifying the profit sharing.
Yes.
Okay. Okay.
Until the college was benefited from the terms of the contract, they didn't question the terms of the contract or any alteration to it. But when they suffered losses,
they are intending to enforce the original terms of the contract to the detriment of my client. The council thus pleads the Honorable Court that the college attempts to enforce the original contract shall not be upheld. If this Honorable Court may permit, the council would like to proceed towards the prayer.
कोर्ट नहीं बोल रहा है कोर्ट बिलीव नहीं वेरी गुड
Are you feeling comfortable?
Yeah,
I can ask questions?
surely, Your Lordship.
Thank you. Yes. What is the relationship between college and Muskan?
It's an employer-employee relationship.
Okay. Is it agency also?
Yes.
It's agency. So every employee is an agent.
The acts of Professor Muskan regarding the meetup, in this case, makes her an agent,
Implied acts.
implied authority.
But what makes you say that she acted impliedly? Just out of curiosity, because happens to be one of the students, she showed some interest in hearing of how the progress was happening with respect to the event,
The letter of acknowledgement bearing the seal and stamp of the college,
which was given before the email.
which was given after the email which my client made to Professor Muskan.
बाद में दिया था हाँ अभी ठीक है अब क्वेश्चन पूछ लो but I think there were some electronic conversations also which happened between the two parties.
It was email-based conversation, whatever happened.
Correct. So what is the bearing between the two, the email and the agreement, allocation agreement? The allocation agreement we agree because that was something which was signed by the board.
Yes.
However, the email was sent by Muskan and not the board.
Yes, Your Lordship.
So how are you inferring these two?
But the letter of acknowledgement was a physical copy.
Okay, but I think email also holds equal validation.
Yes, Your Lordship.
Still not an agent.
She is an agent.
ये कौन सी तरफ से है? अच्छा ये अपीलेंट है क्या? I'll take 2 minutes.
बोला भी आपको बोलना हिंदी
अपने को बोल रहा है एजेंट नहीं है
he does not have any questions.
Wherefore, in the lights of the facts presented, issues raised, arguments advanced, and authorities cited, counsel on behalf of the petitioner humbly submit the Honorable Court to declare the correspondence between the plaintiff and Professor Muskan as a valid and binding alteration of the allocation agreement to further direct the defendant, Global Business College, to refund the amount of INR 30,000 deducted from plaintiff's deposit, order the defendant to bear the cost of this litigation, including legal fees and other expenses incurred by the plaintiff in pursuit of this action, and pass any other order that this Honorable Court may deem fit in the ends of justice, equity, and good conscience.
What order? What costs do you want? How much cost? Do you have
1
a
lakh
ballpark?
rupees.
1 lakh For what?
The legal fees and the
You have
cost.
taken 1 lakh from this child who's trying to recover 30,000. Are you trying to loot him? It should be done pro bono. He is just a bichara student.
It's also the compensation to my plaintiff.
That is different. I'm talking about cost, legal cost.
It's 50,000 and another 50,000 as a compensation to the plaintiff.
50,000. Okay.
कॉस्ट में थोड़ी आता है कॉम्पनसेशन.
वो अब उसको अलग अलग कर दिया. ठीक है. Thank you.
Thank you a lot.
Guys, with this we come to the end of the first part of our final rounds. We are done with the cases related to we are done with the cases related to contract law. We'll take a short break over here for क्या बोलते हैं 45 minutes and then we'll reconvene at 2 to continue with the 7 cases of the criminal law. All right. The judges are rising. You can also rise. जब जजेस उठते तुम लोग को भी खड़ा होना पड़ता है. हाँ. चलो. So guys, we'll see you all at 2 o'clock. Go have lunch. Nobody enters that classroom. जिनके भी friends उस classroom में हैं अभी 7 लोग. Go ask them क्या खाना है और लेके चल जाओ. ये सब नाटक नहीं चलेगा कि हम उनको लेके जाएंगे खाने, ये करेंगे वो करेंगे. Nothing of that sort is allowed. All right. Thank you. Okay, guys, so we are back and we are going to start with the second half of our final rounds. Contract law वाले सारे participants का presentation complete हो चुका है and now we are going to start with criminal law. ठीक है? We'll call the first participant in 5 minutes. We'll start. Okay, guys, so we are going to call our first contestant. That is Sejal Parekar. She's going to argue from the appellant side, that is State of Zindia, in the matter of State of Zindia versus Vishy Mathur. This is the first case जिसमें अपने criminal law को discuss करने वाले हैं. So please pay attention. It's going to be a lot of fun. Woohoo!
नीचे कर Works? Yeah? Yeah. Good afternoon, bench. If it may please the Honorable Court, this is Counsel Sejal Patekar arguing on the behalf of Appellant in the case of State of Zindia versus Vishy Mathur. If the Honorable Court permits, Counsel would like to state the fact of the case. Soham and Vishy were married and had a child, Harry. Vishy was diagnosed with bipolar disorder and was undergoing treatment. On 8 June 2024, following an altercation, Soham was found unconscious with severe injuries on their home. An axe covered in blood was discovered in the garden and Vishy was found nearby in a disturbed state. Soham succumbed
to his injuries, and Vishy was charged with the murder under Section 302 of ZPC. Vishy pleaded not guilty, claiming she was in a maniac state due to her disorder and could not recall the event. The Session Court convicted her, but the High Court acquitted her on the ground of insanity, both legal and medical, leading to this appeal. If the Honorable Court will, I'm sorry. If the Honorable Court permits, the Council would like to state the fact of, raise the issues of the case. Sorry. Hello. The issues of the case is that whether Vishy Mathur can claim the defense of insanity under Section 84 of the Indian Penal Code, and whether the acquittal by the High Court based on the defense of insanity was justified. For which the ground of appeals are the misapplication of Section 84 of ZPC, lack of sufficient evidence of legal insanity, failure to consider Vishy's post-crime conduct, and public policy and precedent. Further, I would request the bench to consider the case of Hari Singh Gond versus State of Madhya Pradesh, page 5 and page 6. It states that Section 84 lays down the legal test of responsibility in the case of alleged unsoundness of mind. There is no definition of unsoundness of mind in the IPC. Court have, however, mainly treated this expression as equivalent to insanity, but the term insanity itself has no precise definition. It is a term used to describe varying degrees of mental disorder. So every person who is mentally diseased is not ipso facto exempted from the criminal liability. A distinction is to be made between legal insanity and medical insanity. A court is concerned with legal insanity and not with medical insanity. The burden of proof rests on the accused to prove his insanity, which arises by the virtue of Section 105 of Indian Evidence Act 1972.
Counsel, but there is legal insanity.
Sorry?
Dr. Amrita has said while the case was there in High Court that there is legal insanity. If you could please refer to point number 9 of the fact sheet.
Just a second. Is the High Court has declared that medical and legal insanity is there, but there is no legal insanity, as in the case of Surinder Mishra versus State of Jharkhand. Just a minute.
How do you define legal insanity?
Okay.
What is legal insanity?
Legal insanity means the accused must have been incapable of understanding the nature of the act, or that it was wrong due to the mental state at the time of the crime. Whereas in this case, Vishy Mathur failed to prove that at the time when the crime was conducted, she was legally insane. There's no foolproof evidence that she was legally insane at the time of the crime.
What kind of evidence what kind of foolproof proof evidence do you expect in such a case? Everything has to be deciphered from circumstantial evidence, na? You cannot get direct evidences in such cases, right? So everything has to be determined from circumstances.
The only witness is Vishi Mathur, na? You have to take that into consideration.
Yes, the only witness is Vishi Mathur, but there are certain changes or certain evidences that are, like in this case, there's a lack of insanity because, just a moment. If the bench could please refer to the case of Surinder Mishra versus State of Jharkhand, page number 9. Here it says that behavior of an accused pertain to desire of concealment of the weapon of offense and conduct avoid detection of the crime go a long way to ascertain as to whether he knew the consequences of the act done by himself. So, which actually means that these sentence that it is implies that if an accused person takes steps to hide the crime, this behavior used as evidence that they were aware of the wrongful nature of their action and important in determining criminal intent, that's mens rea. And such behavior argues against a claim that the person did not understand what they were doing was wrong, as their action suggests that they were aware of the potential consequences and tried to avoid them. The sentence emphasizes that the efforts to conceal a crime can indicate that the accused understood what they were doing and potential consequences, which is crucial assessing in their mental state and the criminal responsibility.
So in this case, how do you relate this proposition of law in the instant case?
That when Vishay Mathur, the Colonel Chirag saw Vishay Mathur crying in the garden, and she was filled with mud and blood. And when the police came over there, and they find the axe hidden in the garden, as the evidence, as it is an evidence that Vishay Mathur had blood on her hands. It said that Vishay Mathur had took the axe in her hand, and she had stated in the fact sheet that the axe was in her hand, and the fact that she tried to hide it in the garden. That means there is a concealment. And
but who knows whether this axe was actually the murder weapon? What if he was murdered with something else and not the axe?
Here in the witness, sheet. Here in the witness, the prosecution witness 2, Dr. Ghai, who treated the deceased, it is said that the death has occurred due to injury in the head caused by a sharp and long object. And even the forensic report says that Vishy had the fingerprints on the axe himself.
I don't think Vishy's fingerprint would make much of a difference, because if something is in my house, it can have my fingerprints irrespective of whether I have used it for the crime or not. But
sharp and long object could be a sword also, not necessarily an axe only.
But Vishy had used the axe as a weapon to...
That's nowhere stated.
That's nowhere stated. Just a moment. If the bench could refer to the Surinder Mishra versus State of Jharkhand, page 11. It has been said that the accused ran away from the place occurrence and threw the country-made pistol, the weapon of the crime, in the well in order to conceal himself from the crime. However, it was recovered later on. The aforesaid conduct, the appeal subsequent to the commission of the offence, clearly goes to suggest that he knew whatever he had done was wrong and illegal. So the fact that Vishay Mathur hid the axe says that she was guilty, and the fact that she was crying, Colonel Chirag saw her crying in the garden, that she was guilty of the crime she had done. That means that if she claims at the time of crime that she was in insane capacity or she had a maniac episode, immediately after the crime took place, she was in the garden. There's a change of place and there's a concealment of the weapon, and such sharp weapon can be used to kill someone.
But she is insane, na?
She claims to be insane. That's nowhere... Sir,
Yeah.
that's medical insanity. Just a sec. Medical insanity, that means that a person is on medicine or the consultation with a psychiatrist or therapist, but are able to make informed decisions and can do for them and lead normal life.
Go to defense witnesses one's claim. What they have proposed before the court. Rishi was suffering from bipolar affective disorder and the disorder was sufficient to enable a person to do any violent act under its influence.
Yes, it states, but that does not say that Vishy was under the influence of
She did not run away from the house. If she really wanted to run away,
But she did run away from the place of crime.
probably she was shocked after looking at her.
Even if she was shocked, she could have stayed there. But she did. May I state one last fact? Yes.
Take your turn. Counsel, the question that I was asking is,
She could have ran away, but she did not.
the case law you just cited, in that case, that guy threw the pistol in the well and ran away, right?
Yes.
In this instant case, she did not run away. She did not even bother to wash off the blood from her body or clothes or whatever, right?
And it takes time to come out from the maniac episode.
She just merely threw the axe in the garden and the police thought it was hidden. She never hit. It could so happen that she never hit
Absolutely.
the axe. She just threw the axe in the
But the fact that she was having mud and blood on her hand.
Because of the garden.
But the blood.
because she saw her husband. That's why
But she stated that she had the axe in her hand and
We are accepting that she is the one who has
She is killed.
murdered,
Yeah.
but she was under the maniac episode.
no, she was not, because the thing that she was immediately in the garden.
Show me the circumstances which proves that she was not. You do understand that circumstantial evidence is something that we need here, right?
Yes, but a person is assumed to be sane unless he or she is proven to be insane. And yes,
She's proved to be insane, na?
she has bipolar disorder. That's why.
Correct.
she is proved to be insane, medically insane, but for a person to be legally insane, it is said that the crime.
But ma'am, she has bipolar affective disorder, na?
She does have bipolar affected disorder, but she
What
nowhere.
does bipolar affective disorder mean? If you could explain that to me.
It's a medical illness that. Okay, I don't have a perfect definition. Sorry, I don't have a perfect definition for it.
Certifies legal insanity. Medical can be done by the doctor.
Yes.
If you're saying she was not legally insane, so who certifies that the person is legally insane?
Okay, I don't know that one certification, but here in the case of Bapu versus the state of Rajasthan, the accused was held to be legally insane by the doctors and the one who examined him in the jail itself. So,
What is the difference between medical insanity and legal insanity?
the difference between medical insanity and legal insanity is that.
We don't need the definition.
Okay.
Just explain with respect to this.
Okay, the medical insanity is when a person is called to be insane and the same has been declared by the psychiatrist that the person is on medication, but at the same time is informed, is in the state to, and his faculties to know what's the surroundings going on. And whereas in legal insanity, the person at the time of the crime should be legally insane, or a person should be insane or should not be, does not know at the time the act is doing is wrong or contrary to the act, but the same should be at the time when the crime is being conducted.
What is insanity? Forget about medical legal. What is insanity?
Insanity is an illness where the person does not know what he or she is doing, or whether it is wrong
or contrary to the law.
Same thing happens in medical insanity as well.
Yes.
Yes. Same thing happens in legal insanity as well.
Yes, but in medical insanity, the person is most of the time or few of the time aware of the surrounding or is informed or in the faculties.
Most of the time or few of the times.
Yes.
So how could you prove that at the time of committing the crime?
So
At the time of committing the crime, she was not legally insane.
So, the section 105 of the Indian Evidence Act states that in such cases where the defense take this, where the accused take the defense of section 84 of the ZPC, it is the burden of proof lays upon the accused to prove that the person is legally insane.
And the accused states so.
Sorry.
The accused states so.
The accused does say so, but that accused does not prove so.
So you prove us wrong. Yeah. She's just denied.
That is what I asked. Create the circumstance. Show me the circumstantial evidence which shows that accused is wrong. Prima facie, I think Mr. Bakul is absolutely correct. She should get the defense of 84.
But ma'am, she does not have any proof that she was legally insane.
So you expect her to give a prior notice of some 8-10 days, inform the neighbors, and then probably commit a crime?
No,
that
but
I'm doing
she
this.
must have some legal, she must have some proof that she was legally insane at the time when she committed the crime.
How do you prove? Yeah.
That's what I'm saying.
What is the kind of evidence that you use in a criminal case? Do you get direct evidences in a criminal case? Can
No.
you find direct evidences?
No.
So what is the kind of evidence that works?
That the person,
Circumstantial evidence.
yes,
How do we define circumstantial evidence? What is circumstantial evidence?
that during the crime or preceding the crime or following the crime, the person.
Circumstantial evidence is the circumstances one by one shows. It concludes that see, this is what has happened. So what we are asking you to do is you show the circumstances that this went wrong, this went wrong, this went wrong. Hence, Vishi Mathur, whatever she is claiming is wrong.
Okay, during the crime, Vishi Mathur used the axe to kill some by the head of the injury, and when Colonel.
Which we believe because she has bipolar affective disorder, that's why.
No, but she was in her in her sanity and her faculties. And later, when Colonel Chirag found her in the garden, she was crying over there. That's because she was in the guilt, and the reason she did not run away was she was feeling guilty for what she have committed, and the fact that she has her.
Counsel, you're making a very strong statement against a patient who has a mental illness. You're just making statements. We are saying that prove it. How to, you are only saying it, no, she was in the same condition. But how do you prove that she was in the same condition?
Just a moment.
She could have at least called the colonel, no? Okay, I'm seeing.
Counsel, you have 1 more minute.
Okay.
Let's wind it up.
Counsel, prayer.
Okay, I'm sorry. I'll just conclude one point and I'll start with the prayer.
टेस्टी लग रही है.
There's no credible evidence to suggest that Vishy experienced a sudden severe mental breakdown at the time that would qualify as temporary insanity. Without such evidence, the claim of temporary legal insanity is untenable, and therefore, Vishy's mental condition did not meet the legal threshold for insanity, that she was capable of understanding the nature of her action and the consequences. Her liability under section 302 of the ZPC remains intact, and
Vishy was in control of her faculties and understood what she was doing. Therefore, this should be held accountable for the murder, considering the post-crime actions of her. And Vishy's action leading up to the following crime is indicating that her awareness and intent. If Vishy attempted to cover up the crime, fled the scene, and expressed guilt or fear of being caught, these behavior, and it says that she was understood the wrongfulness of her actions and the liability under section 302 of the ZPC. So, if the court may permit, I would like to prayer.
Prayer nahi thi? Oh.
In the light of fact, issues raised, arguments advanced, and authority cited, it is most humbly prayed before the Honorable Court to set aside the judgment of the High Court of Zindia, reinstate the conviction of Vishy Mathur under Section 302 of the ZPC, impose appropriate penalties, and sentence as deemed fit by the court in the interest of justice.
Thank you.
Sorry.
जापान में जाके सबको कहानियां सुनाना है व्हाट हैपेंड इन इंडिया इसके जजमेंट
Next contestant is Rakshita Singh. She will be also arguing from the appellant side in the matter of State of Zindia versus Vishy Mathur.
झारखंड धनबाद
Excuse me, you are not going to judge. This particular round you are not going to judge.
इसको पकड़ के रखना होगा ये वो नहीं हो रहा
हमने बैंड हुआ नहीं हो गया ना
ठीक है
हो गया ये लो ये पकड़
Good afternoon, Your Court. If it may please the Honorable Court, this is Counsel Rakshita Singh arguing on behalf of Appellant, State of Zindia, in the case of State of Zindia versus Vishy Mathur. If the bench may permit, the Counsel would like to state the facts of the case.
We know the facts, just move on to the only ego of the defense.
अरे ये appellant इधर respondent थोड़ी है. Give me two important facts.
Important facts. Vishy Mathur was found in the distress stage, covered with blood and mud in the garden, and her husband Soham, unconscious body, was found in the bedroom of their house, and an axe was hidden in the garden was identified as the weapon which was used to attack, which was used as a murder weapon by Vishy and had the fingerprints of Vishy. And the second fact was Soham, in his dying declaration, explicitly blamed Vishy for the attack, proving this direct evidence against her. This declaration was supported by the forensic evidence linking Vishy to the murder weapon. The board may permit. The council would like to state the issues of the case. Sorry, I'm so sorry. The bench may permit. So sorry. If the bench may permit, the council would like to state the issues. First issue is whether the High Court was correctly acquitted Vishy Mathur under Section 84 of ZPC on the ground of legal insanity, despite the initial conviction for murder under Section 302 of ZPC, and whether the defense reliance on Vishy's mental condition was adequately substantiated to meet the requirements of Section 84 of ZPC. The bench may permit. The council would like to state the arguments of the case. Much obliged. The defense had conflicted medical insanity with legal insanity under Section 84 of ZPC. The legal standard required that the accused must be incapable of knowing the nature of the act or that it was wrong on the contrary to the law. In this case, the evidence does not sufficiently prove that Vishy Mathur was legally insane at the time of the crime. Her action, including the concealment of the murder weapon, suggested...
What action exactly? What action exactly?
Action of concealing the murder weapon in the garden.
That proves that she was not insane.
And her behavior at that time when she was...
What behavior?
She was crying and she was covered with mud and blood.
Covering with mud and blood is a behavior?
No, I'm sorry. Her state... suggested awareness and intent with contradicting the claim of legal insanity. The council wants to present the prosecution evidence. The council wants to highlight the testimony of the investigating officer PW1, who stated that Soham in his dying declaration blamed Vishy for the attack. Additionally, the forensic report confirmed that the axe, a weapon capable of causing fatal injury, bore Vishy's fingerprint. The another evidence, PW2, it stated that the cause of death was head injury inflicted by a sharp object, which while...
Ma'am, PW1 and PW2 does not prove that she was not insane. The court believes, the bench believes that she was insane and she gets the benefit of Section 84.
Yes, Your Ladyship, but the way she... but the evidence which was... the forensic evidence proved that she was insane. She was not insane at that time. When
Which forensic evidence proves that?
It's still...
In fact, the psychiatrist has deposed before the court that she was mentally unfit and her mental disorder was sufficient to make her violent and all that jazz.
I apologize. But the injury which she made by the weapon was sufficient that she did it. If she had not done it intentionally, then she would have not kept the weapon in her hand when she came back, as per her statement, when she came back into the consciousness. She said that she was holding the murder weapon in her hand, and it was...
Before whom did she make that statement?
Before the police at the time of investigation.
Statements made before the police are not admissible in the courts of law, so we don't accept that statement.
her mental disorder was for a frequent time. She could have said wrong in like to protect herself from harsh jurisdiction. She could have said this statement that she was insane at that time. There is no evidence to even prove that she was she was insane at that time. Ma'am.
But tell me something.
No.
Okay, listen, in cases like this, you will never get a direct evidence showing that she was mad, right? You cannot have a CCTV camera showing her madness wala behavior, right? So we'll have to look into the circumstances. Now, if you look into the circumstances, her being mad, would she ever would a normal person kill somebody and then stay in the same premises and start crying and sobbing and all of that? No, they would try to run away, right? Did she try to run away?
No, because
Exactly.
she was having that medical issue. Na?
She was-
It was her excuse.
No, not excuse. In reality,
Yeah, I agree with you. But at the time when she did that incident, she was in her. It is assumed as.
so basically she was in her senses when she killed him, and then she slipped into that manic phase
No,
because
she
of.
didn't slip. She just gave the excuse that she was. She slipped.
I got it. So what she's trying to say is she had this plan in her
Yes.
mind that she's going to use this excuse, which is why she didn't run away.
Yes.
You get it?
Yes.
Why didn't she run away ना?
Because she had this plan to take this defense.
तो आप बोलना चाह रहे हो कि उसको पहले से पता था कि सेक्शन 84 का डिफेंस मिलेगा? Smart.
She knew that she will get the defense of her
Section 84.
her pagalpan.
हाँ मतलब insanity section 84. Knowledgeable.
Do you think Colonel Chirag was involved in all this?
Colonel Chirag was not actually involved because he found all that situation where she was crying and.
बट ऐसे क्यों कर्नल चिराग को ही क्यों सुनाई दिया? ऐसे आसपास और नहीं बन रहे थे?
And what was the colonel doing at home at 1 o'clock in the afternoon? Did you think about it? I think there was something cooking up between Vishy and Colonel Chirag, because of which they concocted the entire plan. What do you think?
It could be, but might be.
So in short, you are trying to say कि she knew that she'll get a defense of her insanity under section 84.
Yes.
तो सोचा मौके पे चौका मार लेते हैं.
Yes.
Ma'am, time is up.
If you, yeah. Please, can you grant me a bit time more?
Sure. Thank you.
Thank you. Should I?
हाँ मैम. Ma'am, any evidence?
Yeah, sure. Ladyship, I'm giving.
Wait.
Could you please?
Sorry. I apologize. My apologies.
Ladyship, can you please refer the case of Surendra Mishra versus State of Jharkhand?
Okay. Surendra Mishra?
Versus State of Jharkhand, 2011.
अच्छा हाँ okay हाँ.
Where Surendra Mishra killed his wife, taking the advantage of mental disorder, but the incident occurring under circumstances where Mishra, allegedly suffering from mental disorder, attacked his wife with a sharp weapon, leading to her death. In para 1, it is stated that Surendra Mishra was held guilty on both the court and sentenced him to undergo imprisonment for life under section 302 of ZPC. And para 12 says that it was found that Appellant was not suffering from unsoundness of the mind at the time of commencement of crime, and therefore the decision relied on no way advancing the case of Appellant.
Why was this Surendra Mishra found to be not guilty or guilty, whatever? What were the facts of the case that led to the conviction of Surendra Mishra in this case? Apologies.
I apologize, I don't have answer for this.
So why are you citing this case then?
I said, but I was having evidence. Okay.
Okay.
Can you
Any
please
more
repeat?
evidence we have?
One more case I have. Another case. that- In the case Ratanlal versus State of Madhya Pradesh, the Supreme Court emphasizes that burden of proving insanity lies with the defense. The court held that the mere presence of mental illness is not enough. It must be proven that accused was incapable of understanding the nature of act at the time of the crime. Any question? Yes. I- Should I proceed?
Acha, what to see? Okay, so there was one more defense witness. We should talk about him also. So, Jugnu, who's Vishi's brother, has deposed that she used to get aggressive and violent for petty reasons. So, don't you think this would have been the case here also? So, हमने कुछ बोला होगा, वो चिढ़ गई होगी, रोने लग गई होगी, मारने लग गई होगी, and then she got a manic episode.
Yes, that was a very manic episode.
मतलब वो दौरा
Yes, sir, I get it. I forgot the question.
My question was that this Jugnu guy, who's Vishi's brother,
Yes.
he has said that कई बार ऐसा होता था कि बेमतलब का Vishi started to cry and aggressive हो जाती थी.
फैक्ट में दिया हुआ है कि उनके झगड़े पहले भी होते थे.
हाँ, तो ऐसा भी हुआ होगा ना कि यहाँ पे हमने कुछ बोल दिया होगा, इन लोग का झगड़ा हो गया जिसके वजह से इसका वो बीमारी दौरा ट्रिगर हो गया and because of that बीमारी.
दौरा.
Sorry, madam.
आपको ये पता है केस में हो क्या रहा है?
Yes. Very well, I know.
हाँ चलो ये बता दो बाइपोलर डिसऑर्डर क्या होता है?
It is a mental disorder which attacks Mirigi.
Fantastic.
Sir, as you said that as per his her brother Jugnu, he said that often she was getting this kind of problem. So, but this was this could be the reason that as during her that anger issue and all violence issue, she would have killed her husband. Yes, there is a possibility, but it doesn't. He doesn't say that she slipped into that mental disorder.
So you are saying because of her anger issues, she killed Soham, not because of this disorder.
Yes. Yes.
And why would she have anger issues? Who says she had anger issues?
Oh, sorry.
She didn't have anger issues.
She had anger issues.
What makes you say she had anger issues?
Vishi's brother Jugnu said that she had the anger issue, but
But
but she when she killed his husband, she was it doesn't prove that she was in her anger state or somewhat like that. She would have done her intentionally, not due to anger and maniac problem.
okay.
I would,
Ma'am, last question.
yes.
What exactly is bipolar disorder?
It is a mental stage where where the person who is suffering from this mental problem, illness, doesn't gets to know that what action the person is doing is right or wrong or whatever the action is done by them. They are unaware of the action done by them.
Very generic and smart answer.
If the bench permits, the council would like to say the prayer. No issues. Issues? Oh, I said the issues. Should I proceed?
Any more questions? I think I'm convinced.
Masha applies in the lights of the facts. In the lights of the facts stated, issues raised, argument advanced, authority cited, it is most humbly prayed before the Honorable Court to set aside the High Court's judgment of acquittal and reinstate the conviction and sentence imposed by the Session Court under Section 302 of ZPC for the murder of Soham Mathur and pass any other order that the court may deem fit in the interest of the justice.
No, I have one question, Lekin. No? What happens to the child?
Child was sent to the government child care center.
That was because Vishy was in the custody. Now, when we leave her, should we give the child back to her?
I don't think so that child should be returned to Vishy because she was having that mental issue, and she could have fattened her child also.
So just like she killed her husband because of the mental issues, she
Yes.
could also kill the child.
Yes.
So you agree she killed the husband because of the mental issues?
But at the time when she killed her husband, she was not. There is no proof that she was in that mental disorder. There is no proof. So, no question can be.
Should we give the child to her or not?
No.
Okay. So the child should be in the
Custody of government child care center or to the parents of Soham.
not Vishy's parents.
Yeah, it could be Vishy's parents too.
Okay. Thank you.
Thank you.
Next up, we have Isha Patil, who will be appearing from the respondent side, that is Vishi Mathur's side. She has to prove that Vishi is not mad. I mean, Vishi did not do what she did in the episode, Manic episode, Mirgi ka Dora ke Dauran. Order, order. The court is in proceedings, everybody.
चालू है Honorable greetings, may it please the court. If it may please the honorable court, the council would like to refer the bench as your lordship. Sorry? If it may please the honorable court, the council would like to refer the bench as your lordship.
But you have two ladyships as well, no?
So your ladyship.
Okay. So your lordship and ladyship.
Okay, sir. Thank you. The council is deeply honored at the opportunity to present respondent's case in the honorable court in the matter of State of Zindhya versus Vishi Mathur. The council seeks permission to state the facts of the case.
Two important facts.
Yes, your leadership. Basically, in this case, there was Soham and Vishi were married to each other, and Vishi was diagnosed with bipolar mood disorder. One day, Chirag heard some cries from their house, and he went to the house. That time, he saw Vishi was sitting in the garden, and Soham was lying unconscious in his bedroom. These are the two major facts. The council seeks permission to move towards the issues of the case. There are three issues in this case: whether the petition is maintainable in Supreme Court of Zindhya, whether there are sufficient grounds of legal insanity exists so as to exonerate the accused from the liability of murder, and whether the burden of proof of legal insanity is on defense or prosecution. The council seeks permission to move towards the submissions. Much obliged.
What exactly is 136?
136 special leave for appeal.
And when do you file a SLP?
Special leave petition is basically it is filed when there are some exceptional circumstances or some such special circumstances where there is a discretion of Supreme Court, and it can be filed whether for the appeal of either tribunal court or sessions court. Or
But why are we not going under Article 134?
Ma'am, we are opposing the petition filed by the other party. We are saying that the petition is not maintainable.
She is saying 136 is not maintainable. Where should,
Okay.
how, under what article should we?
Yeah, correct. What should have been the jurisdiction?
Basically, we are 134 can be.
What is 134?
134 is the appellate the appellate jurisdiction for criminal cases.
So okay, first you raise your arguments with respect to first one, then we'll talk.
Okay. The Article 1, the appellant has filed the petition under Article 136 of the Constitution. Article 136 of the Constitution is the corrective jurisdiction, and also it is exercised when there are special and exceptional circumstances. In this case, there is not a corrective jurisdiction also, and not there is any special or exceptional circumstances. In the case of Himachal Pradesh administration versus Shri Om Prakash, it has been stated that the special leave for appeal against the acquittal under Article 136 of the Constitution, there is undoubted power to Supreme Court to interfere in the undoubted power of Supreme Court to interfere in the findings or evidences, but it is not the court does not ordinarily interferes in it as unless there is any improper or perseverance in done by the High Court. So basically, in this case, neither of this is done. So the council pleads that this petition under 136 is not maintainable.
Should be rejected. It is maintainable,
But it should be rejected. The council seeks permission to move towards the second. The second issue is whether there are sufficient grounds of legal insanity to exist so as to exonerate the accused from its legal liability of murder. According to, in the case of Bapu Garat Singh versus State of Rajasthan, Section 84 of IPC is been defined, which states legal insanity. Legal insanity means a person is suffering from mental illness and also have loss of reasoning power, which also includes incapable of knowing the nature of the act, whether the act is right or wrong, or whether it is contrary to the law. The main essential criteria of a crime are actus reus and mens rea. In this case, neither of also in case of Bapu Garat Singh versus State of Rajasthan, it has been stated that act is not crime unless done with a guilty intention. And also in the case of Dayabhai Chhaganbhai Thakkar versus State of Gujarat, it's been stated in the absence of mens rea, conviction under section 302 is unsustainable. So in our case, there was no guilty intention of respondent. Also, there was no mens rea. In this case, there is no evidence of intent as to no indications of family hostilities done towards the appellant, and so it is hard to believe that anyone can kill so brutally in this case.
So you are saying there is no intention.
There is no mens rea present in this case.
What all constitutes mens rea?
Mens rea, basically the motive should be there to commit a crime.
What if I have the knowledge that what I'm doing is probably a crime? Is that sufficient to be considered to be mens rea?
No, sir. Basic motive should be there.
Your time is up.
I request Honorable Court bench to please extend time.
Yeah, so when we talk about mens rea, does mens rea But can mens rea be proved only by way of intention?
No, sir.
What if I have knowledge that I'm doing something which might be wrong or which might cause injury? Does that also constitute mens rea?
No, sir. The major thing, motive is important over here.
Motive is important in cases of
Yes.
crime?
Just the motive can prove intention.
No, sir. Motive and intention are basically in mens rea. The major criteria is motive.
What is the difference between motive and intention?
Intention is basically I want to do something, and motive is the reason behind
Why you want to do that?
why I want to do.
Do you think motives are important for crimes?
Sir, intention.
No, motive. Is motive relevant for
Yes,
crime?
yes, sir. Yes, sir.
ठीक है.
What about knowledge?
Knowledge is important, but in our present case, as she is not mentally capable, knowledge. Shall I proceed? Thank you. Also in the case of Geron Ali versus King and Rupesh Manager versus State of Sikkim and Ratan Lal versus State of Madhya Pradesh, the accused were acquitted. On the plea of unsoundness of mind, where they have create sufficient amount of doubt in the minds of honorable court. Also, and in the case of Surinder Mishra versus State of Jharkhand and Hari Singh Gond versus State of MP, the major thing here, it was being stated that to prove insanity, medical insanity should not be proven, legal insanity should be proven. Legal insanity is under section 84 of IPC, which means basically the person is incapable of understanding the nature of the act, whether the act is right or wrong, or whether it is contrary to the law.
So what is the difference between medical and legal insanity?
Medical insanity is a large concept. Medical insanity includes legal insanity, but legal insanity does not include medical insanity. Now can I proceed? Thank you. So basically in our case, the accused has been dealing with the bipolar mood disorder, which is treated as a legal insanity, and she was unable to understand what the crime was done, as bipolar mood disorder is manic depressive illness in which there are mood swings.
Counsel,
Yes.
in order to prove legal insanity, you have referred to a major rule which is always used in cases, McNaughton's rule.
Yes, ma'am.
And there are two major criterias in McNaughton's rule.
Yes.
Major criteria and minor criteria. Can you please explain that?
Ma'am, major criteria
And which one are you using for your particular case?
Ma'am, magnetic rule, in McNaughton's rule, we are majorly dealing with the major criteria in this case in McNaughton's rule is where the person has mental illness at the time of the crime, while the minor criteria covers where they did not. So in this case, we are dealing with the major criteria of the McNaughton's rule, whereas we are referring to mental illness. The accused was having mental illness at the time of the crime, at the time when the offense was committed.
So you're using the major criteria.
Yes, yes, Your Honor.
And can you use facts of the case to prove how you're using the major criteria?
Ma'am, according to the facts, Vishy has clearly stated that she did not understood, or she was not aware from how the offense took place. She had stated this to investigating officer also. So at that point, if we say if we consider the fact Vishy was also under treatment of bipolar mood disorder, and by taking the defense witness 1,
that is Dr. Amrita. She also has given reports, and she also has stated that there are major aggressive mood swings that Vishu was facing. Also, if we look into bipolar mood disorder, there are various moods, and that mood controls the behavior of a person, and that moods are on extreme level. So a person is unable to understand what he is doing, or what actually act he is committing. Also, in some of there are
Counsel, what's your source for this definition of bipolar affective disorder? What's the source? Why should we believe you what it means? Do you have a source, any medical source, WHO, anything you've cited?
Yes, ma'am. I have referred to some of the articles. The bipolar mood disorder is listed in DSM 4 TV. This has been given in the compendium. The article is being given in the compendium. Also, some of the medications which are being referred by doctors in bipolar mood disorder are also being given in the compendium.
The articles that you have given are from from a UK website, right?
Yes.
Why should we believe what's written over here? Do they follow what UK websites say?
So basically, they are medical articles. So
they're going to be the same throughout the world.
Shall I proceed? May I request counsel? The counsel requests the bench that shall I move to my third issue? My third issue is whether the burden of proof of legal insanity is on defense or prosecution. In insanity as a defense, two major aspects are to be proven. That is commission of crime, and second, insanity as a defense. So, commission of a crime is basically prosecution has to prove a commission of crime beyond reasonable doubt, and onus of proof is on
Prosecution.
No, is on accused defense under section 84 of IPC with section 105 of Indian Evidence Act. So, and here a reasonable doubt should be created in mind of court.
With respect to the burden of proof that is on you, with respect to whether 84 applies to you or not, do you have to prove that beyond reasonable doubt, or preponderance of probability would work over here?
Preponderance of probability works.
And for them?
For them, reasonable doubt beyond reasonable.
Do you have a case law that says that?
Yes, sir.
No, the case law that says that 84 can be proved by way of preponderance of probability. For them, we know it's beyond reasonable doubt.
So I have a case. In Ashok Bhosle versus State of Maharashtra, decided by Supreme Court, it has been held that the burden of proof on party accused is to only satisfy the preponderance of probability, making it similar to civil situation in which the benefit is claimed. Ashok Bhosle versus State of Maharashtra. Yes, Your Lordship. Sorry, Your Lordship. Anandrao Bhosle versus State of Maharashtra. May I proceed? Yes, Your Lordship. Also, in the
Counsel,
case
but we don't believe that the benefit of section 84 should be given to Vishy Mathur. We believe that whatever she was doing, she was sane enough to understand the consequences of her act. She tried to hide the acts. And why on earth would an X be there in the bedroom of a person?
Yes, Your Ladyship. There are many situations, or there are many a times in village, or in many a times in cities also, people keep
Where X is there inside the bedroom.
not inside the bedroom,
Then?
Your Ladyship, but it is present inside the house.
It might be there in the garden. what the hell it was doing in the bedroom.
Ma'am, basically we are dealing that Vishi Mathur was a patient of bipolar mood disorder. In aggression, the aggression level is on such a peak that she is unable to understand what is happening with her. I'm not talking about the actions, but the mental capacity to understand what is to be done, whether she is taking the acts, whether she is doing anything.
But she is sane enough to understand कि मुझे कुल्हाड़ी लेकर आनी है, इसके सर पर ही मारनी है और सर पे मारने के बाद उसको छुपाने के लिए जाना है.
Ma'am, the aggression is unable to control. The aggression, the mood of.
But how do you justify the ex? बेडरूम में और कुछ भी हो सकता था, उठा के मारने के लिए एक्स ही मिला. थप्पड़ ही मार देती. हाँ, चप्पल मार देती.
Your leadership, but actually there are in the fact there are no such specifications mentioned that what all was present in the.
But मतलब common understanding पे भी what we understand is X is not something, not a decorative item that's present inside the bedroom.
Yes, your leadership. But in this case, I will be majorly focusing the also according to the reports of Dr. Amruta itself, there are situations where a person gets or the accused gets so the person who is facing this disorder gets so aggressive that he is unable to understand the act, ma'am. Your ladyship.
I agree that, but what was the ex doing inside that room? I believe it was pre-planned. अगर एक कुल्हाड़ी किसी के घर में है तो वो गार्डन में हो सकती है, वो रूम के अंदर क्या कर रही थी? और सोहम knew that she is suffering from bipolar affective disorder. Even he knows कि अगर उसको कुल्हाड़ी को घर के अंदर रखा तो it's dangerous, right? Why would he keep it inside the bedroom?
Yes, your ladyship. If we try to, there is no motive, ma'am. That there should be a motive that she should. There should be a motive that she should have planned this. There is no motive for her to plan all such things, ma'am. And as there is no motive, and as there is presence of this bipolar mood disorder, where her aggression level is on peak, the accused is unable to understand the consequences.
Ma'am, counsel, see, for taking the defense of section 84, your conduct before the act and after the act is taken into consideration, right? So your conduct before the act, that is the arguments and everything, okay? Then you holding the X and then hitting it on his head. Okay, I can assume ki the level of aggression you cannot understand, right? After the act is done, she herself confesses that she was holding the X in her hand, right? Then she goes to the garden, she hides it, which means she understands that she has done something wrong.
Yes,
so before the act and after the act, the conduct clearly shows that she was at least sane enough to understand that whatever she is doing is wrong.
Your leadership, I would like to state you that before the act, her aggression level was on peak, so she did the offense.
How do you say that aggression level was on peak?
Ma'am, because there is no motive. Otherwise, there is no motive.
But इनके झगड़े तो पहले से चलते चले आ रहे हैं.
Ma'am, but
the fact sheet clearly says that they have been arguing पता नहीं कब से.
Ma'am, but fact sheet also mentions that because of the disorder, her aggression, the fights were being taking place.
She was having medication, condition had gotten better.
हाँ, her medical condition has gotten better. There was a positive change.
Ma'am, actually, there was only there was also not 2 months period from medications to the.
How do you know there was no 2 months period?
Because before 2 months, her child was born, and after that, her medications. After that, she was being diagnosed with this disorder, and after diagnosing, then when after that, Soham basically started. In the start, he used to neglect the symptoms. Then later on, when this happens, fights and all have increased, he took her to the doctor.
But irrespective, the fact sheet says that the treatment and medication had a positive effect, right? So it means that there was a situation when she was worse, her condition was worse, then she didn't think of killing him. And now you're taking this plea that when she's taking medication, she's undergoing treatment, then she just had one maniac attack and she just killed him. Yes. So the problem is not with respect to her disease. The problem is with respect to your story and the fact that she got an axe into the bedroom, and after the murder, she hid the acts. They don't align with each other, you know.
Yes, Your Lordship. So, Your Lordship, the medication, she was on medications, and the medications, to have effect of that medications, it as they are mental medications, there is no specific period, and so the effects of the medication may arise or may not. Also, I have also stated a case which also states the worst effects of the medication, which also sometimes lead in aggression level, rise in aggression level. So in some of the cases, I'm not saying all cases, but in some cases, aggression level also increases in spite of the medications being taken, as I have also cited a case, an
Okay.
example of case.
Okay. Proceed.
Yes. Thank you, Your Lordship. In the case of Dayabhai Chhaganbhai Thakkar versus State of Gujarat, the doctrine of burden of proof is being explained here. Firstly,
That you have sufficiently explained and established that the burden of proving the crime happened is on prosecution, the burden of proving 84 is on you, but yours is preponderance of probability, theirs is beyond reasonable doubt. This you have proved.
okay.
This is settled.
Okay, oh, yes, Lordship. Ladyship. In the major thing I would like to focus is here, that medical examination has to be done by the investigating officer just immediately after the accused has been held, and this was also been stated in the case of Babu Garat Singh, that in the case of previous history of insanity of appellant, the honest investigator has to do medical examination, but in this case there was no medical examination done. So this creates a reasonable doubt in minds of the court. Also, in the if we refer to dying declaration, which has been given here, majorly, if we come over here, dying declaration is not actually that relevant to our part, because dying declaration deals with dying declaration? 32 of Indian Evidence Act, and dying declaration in dying declaration, the deceased has only mentioned that the accused has harmed her, but it is not mentioned that accused was insane at the time of murder. So dying declaration is basically not that relevant to our part. Also, if we refer to the case of Devidas Loka Rathod versus State of Maharashtra, the appellant here was acquitted for creating sufficient amount of doubt in the mind of court, and prosecution was not able to create reasonable beyond reasonable doubt. In the lights of facts of the case, issues raised, arguments advanced, and authorities cited, the respondent humbly requests the Honorable Court to quash the appeal made by the appellant, upheld the order made by the High Court, and to acquit the accused for the murder under Section 302 of Indian Penal Code, and or pass any other order that is deemed fit.
But do you still believe that custody of child should be given to Vishi Mathur, considering her bipolar affective disorder?
Yes, Your Ladyship. For time being, till her situation or till her mental disorder is brought to better position, the child could be kept in the government care center itself, and till then Vishi Mathur could be sent to rehab or medical centers. Thank you.
एक्सचेंज करवा लेंगे इससे. तो आज कुछ तो पकड़ाएंगे. Yes. So shall we move ahead? Next up we have Tanish Porwal who will be representing the appellant. State of Zindia in the case of State of Zindia versus Vishy Mathur.
नंबर मिलेंगे ना. Good afternoon, bench. If the honorable bench may permit, counsel would like to present the memorandum of the case. If it may please the honorable court, this is counsel Tanish Porwal fighting on behalf of State of Zindia as an appellant in the case of State of Zindia versus Vishy Mathur. If your lordship may permit, counsel would like the permission to address the bench as your lordship. If your lordship may permit, counsel would ask the permission to address the fact of the cases. Okay. If your lordship may permit, counsel would request to raise the issues of the case. The first issue before the Honorable Supreme Court is whether the Honorable High Court have applied Section 84 in a correct manner or not. The second issue is whether bipolar affective disorder is a sufficient ground to claim the legal exemption under Section 84. And the third issue is that there was sufficient evidence to establish whether Vishy committed the murder or not. If the lordship may permit, counsel would ask the permission to move towards arguments. Okay, so first argument is misapplication of insanity defense. Honorable High Court have misjudged the insanity defense as Section 84 referred on page number 15. If lordship may please refer to page number 15. Yes, ladyship. Act of a person of an unsound mind. Nothing is an offense which is done by a person who, please note, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of that, or that he is doing what is either wrong or contrary to law. In the case of Vishy, she was aware that what she was doing. It can be proved as there was loud noises from the house of Vishy and home, which circumstantially proves that there was a fight between them. When the fight begins, fight got on a point where Vishy loses her confidence. So she goes to the garden, pulls out an axe and hit the Soham on his head. So there is no chance of survival. So she was aware that what she was doing. It can also be stated that she can use anything that is present in the bedroom, but she chooses to go in the garden and brings out an axe. She can hit on any part of the body, but she chooses to hit on the head. So that is where it can be proved that she was aware what she was doing. What if the axe was already in the bedroom? An axe can't be used in the bedroom as a showpiece. The second thing is that it was contrary to law.
She knows that it was contrary to law, as she tries to hide the axe in the garden and gives the wrong statement to the police that the axe was in her hand, but it was not so. It was hidden in the garden, so she knows that it was against the law. So it can be proved that misapplication of insanity defense is been there by the Honorable High Court. My second argument is based on the Vichy act was intentional. She knows what she was doing, and it can be proved as there was loud noises from Vichy and Soham house. She can use anything to hit the Soham, but she merely chooses to bring out an axe and hit the Soham. She can hit on any part of the body, but she chooses to hit on his head. After the incident was done, instead of trying to save her husband life, she chooses to she finds it more relevant to hide the murder weapon in the garden. And also even when she came back in her senses, she finds it more relevant to hide the evidences and give wrong statement to the police. She stated in her statement that the axe was in her hand, but it was not so. No. It was hidden in the garden. That has been stated by a PW1 investigation officer. Soham's right and interest must be considered. Vichy even now possesses a greater risk to the society and especially to the Soham's family. Soham's loved ones and family have a right to get the justice, and Vichy is a risk to society because of her mental incapability to think and automatically react to the situation. So she must be. Yes.
Right? So Vichy has killed Soham.
Yes.
His family is the one who they have a right to justice. Why is state of Zindia suing Vichy Mathur in the court?
Because we wanted that Vichy Mathur should be convicted under 302 of IPC,
Right.
and the exception under section 84 is not can't be
No, all
applied in
that
this
we
case.
understand. I'm asking why is state of Zindia? For that matter, in every criminal case, why is it the accused versus state of MP, state of UP? Why is it like that? Why does the state sue in the court of law?
Because it is the legal responsibility of the state to pursue that. My next argument is based on burden of proof. The burden of proof that it comes under general exceptions under any case lies on the accused. It can also be proved by the case. Hari Singh versus State of MP. If Lordship may please refer to page number 40.
Which case is this?
This is the case of Hari Singh versus State of MP. Just a second, Lord. Page number 40, para 9, the highlighted part. The section itself provides that the benefit is available only after it is proved that at the time of committing the act, the accused was laboring under such a defect of reason from disease of mind, and not to know the nature and quality of that he was doing, or even if he did not know that it was either wrong or contrary to law. And also, if Lordship may please refer to page number 41. For establishing the legal insanity, it is very important to establish the fact, highlighted part, behavior, antecedents, attendants, and subsequent to the event may be relevant in finding the mental condition of the accused at the time of the event. The behavior that Vichy's nature was very angry, which can be proved by DW2 as in his evidences. Antecedent is that she prepared that she brings out an axe and hit the Soham on his head. Can be antecedent. Attendant can also be this same. And subsequent is she tries to hide the murder weapon. So it can be subsequent. So.
And she was crying, sitting there on the mud and everything. If she had the knowledge or the mental ability to hide the weapon, she could have also run away, no?
Counsel, please refer to page number
You are the counsel. I am judge.
Lordship, please refer to page number 26. 26? Yes. In the case of Sherali Wali Muhammad versus State of Maharashtra, highlighted part, last para, the mere fact that no motive has been proved why the accused murdered his wife and the child, or the fact that he made no attempt to run away when the door was broke open, would not indicate that he was insane or that he did not have the necessary mens rea for the commission of offense. So the fact that he does not run away can't be proved. Also, there are yes, please.
Okay.
Okay, so there are also various circumstantial and oral evidences. That is, the first evidence is of PW1, whereby investigation officer blamed the accused Vishy, and he also deposed before the court that the object was recovered from the garden of Vishy's house. Also, in PW2, the daughter Ghai, who was treating the Soham, also established that the injury was fatal enough. If she was mentally insane at that point of time, she can't do the act which was fatal enough to kill a person. And also, the evidence is that the evidence that is being given by DW2, Jugnu, that it also establishes a fact that she was of very aggressive nature and she becomes violent for petty reasons. Now,
what does this prove?
This proves that there is a mere fight between Soham and Vishy, which generally happens between a Kamal, but she was of aggressive nature, so she decided to bring out an axe and murder Soham.
Okay. What if it was just a coincidence that X was there in the bedroom?
It can't be, but we are fighting on a criminal case, so we can't rely on the assumptions.
Can you tell me so you are relying on the dying declaration also, I'm assuming?
Yes,
Sorry, no assuming, I'm saying.
Yes, because it can be considered as a relevant fact.
Under what section?
Yes, sir. Yes, Lordship. Just page number 56, Lordship. Statement by persons who cannot be called as witness. Highlighted part.
Page number
56. 56. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which cases of the person's death came into the question, such statements are relevant whether the person who made them was or was not at the time when they were made under exception of death or not. So it proves that it is a relevant evidence under ZDA. Zindian Evidence Act.
Okay.
In the lights of facts.
Counsel, 2 minutes.
Yes. It is a Supreme Court case, ma'am. It was examined by High Court, but the appeal was filed before the Supreme Court, where the judgment was not changed. The appeal was dismissed.
What was dismissed? Appeal. Sorry. अच्छा. और कुछ?
One question I have, counsel.
Yes, please.
Okay. No. When we talk about the burden of proof with respect to the plea of insanity, the burden of proof is on the other party, the person, the accused who's taking that plea, right?
I plead to differ, Lordship.
तेरे favor में बोल रहे but okay.
No. Burden of proof. In the same case, Hari Singh versus State of MP.
Page number?
Just a second, Lordship. Page number 38, para 5, highlighted part. Second highlighted part. So every person who is mentally disabled is not ipso facto exempted from criminal responsibility. A distinction is to be made between legal insanity and medical insanity. A court is concerned with legal insanity and not with medical insanity. The burden of proof rests on the accused to prove his insanity. So it is not the burden on the prosecution, it is the burden on the
I was
accused.
saying the same thing. It is
Sorry,
the
Lord.
burden is on the accused.
Yes, yes.
My question was, when the prosecution tries to prove that a person is guilty, they have to prove beyond reasonable doubt.
Yes.
So same way, when a person is trying to prove that they were insane at the time of commission of the offense, do they also have to prove beyond reasonable doubt, or do they have to just prove it by way of preponderance of probability?
It should be proved by preponderance of probability. Just in case if Lordship refer any question so that I can refer it. Okay, if your Lordship may permit, I would like to move on to the prayer. In the lights of facts stated, issues raised, argument advanced, and authority cited, it is most humbly prayed before the Honorable Supreme Court that to set aside the order of High Court and to convict the Vichy under Section 302 of ZPC. Thank you. This is the prayer.
तीन बाकी है ना? हाँ. Guys, we'll take a small 5 minutes का break and then we'll continue. ठीक है? अब हाँ सोचो सोचो आप. Okay, so we are going to resume with our rounds now. The next speaker is Niyati Jain, who will be representing the appellant, State of Zindia, in the matter of State of Zindia versus Vishy Mathur.
Hello. वो नीचे कर रहा है. Hello. Should I start? Good afternoon, bench. If it may please the Honorable Court, this is Niyati Jain, the counsel appearing on the behalf of the appellant in the matter of State of Zindia versus Vishy Mathur. If it may please the Honorable Court, the counsel would like to represent the bench as your lordship. Thank you, your lordship. The counsel would like to make the submissions of the... If the court permits, the counsel would like to move towards the facts of the case.
Keep the facts, move directly to the issues. Will not cut your marks. You will use your facts in the argument.
So, thank you, your lordship. If the Honorable Court permits, the counsel would like to move towards the issues of the case. The issues of the case are whether Vishy's condition of bipolar affective disorder and her claim of experiencing a manic episode at the time of the incident exempts her from the criminal liability under Section 84 of the ZPC, and whether Vishy, the accused, should be punishable under the Section 302 for murder. If the Honorable Court permits, the counsel would like to move on to the arguments of the case. Thank you, your lordship. The counsel would be arguing on this issue in 2 points. Firstly, the intention of the person to murder. As stated in the facts of the case, Vishy Mathur confessed in front of the police. Confessed in front of the police that when she slipped out of the mania, she found Soham lying on the floor of the bedroom and an axe was present in her hand. Also, it was deposed by the investigating officer that the dying declaration made by Soham and the forensic report about the fingerprints, and the doctor Ghai, who treated the deceased, deposed to the doctor that the injury was caused due to a sharp long object, which is through the circumstantial evidence it is seen to be an axe. Soham lay unconscious with a pool of blood around him and had various injuries on his body, scratches on his body. And when police came and investigated Vishy, it was found that she had hit the axe, and the axe was recovered by the police. After the intent of the person to murder was derived as when Vishy slipped out of her mania, she was in the bedroom with an axe in her hand, and Soham lay unconscious. He was not dead, but he was only unconscious, and it was found by Colonel Chirag that Vishy was in the garden. So it is interpreted that when Vishy could help out Soham with her by calling the ambulance or taking some preventive measures, she did not do. Instead, she went to the garden, and she was crying there, and she was full of mud and blood. This shows that she didn't try to save him, but it was her intent, and she didn't try to run away, because if she would run away, it would be a confirmation that she had done something. Instead, she went in the garden and she pleaded. She went in the garden with the intention that she could plead in front of the court that because of this mental issue, she was not able to predict, and then she committed it.
Okay, Vishy is not a medical expert, right? So if she is seeing her husband lying on the floor with an axe attack on his head, there is a very fair chance that she might just believe honestly that the person was dead. And that is why she didn't try to call the ambulance. There's a high possibility that it could happen, right?
Yes, yes, Your Lordship. But if seen, even if she didn't even try something. If she could try something, the person could be saved.
But you need to understand her disposition also. She was in a manic stage. She came out of it and she saw that she had hit her husband with an axe on his head, and the husband was lying on the floor with a pool of blood around his head. For a woman who's married, to see her husband like that is a very shocking episode, right? So probably because of that shock that she had, it didn't even cross her mind to check for the pulse or the breathing or something like that. She just assumed that the person was dead, which is, I think, fair.
Yes, Your Lordship, but it was a deliberate action of Vishy. It was not that she was in a manic state, but it was a deliberate action which is proven here. Which you are trying to prove. The next, I would like to refer a case, George Pentia versus State of Andhra Pradesh, which is a Supreme Court judgment, where it was stated that hiding of a weapon is a clear attempt to destroy evidence, and this is evidence tampering, which was treated as a severe factor in sentencing, and it shows that the accused wanted to avoid the detection of the police officer, and
But if the accused really wanted to avoid detection, she would have just run away, or at least cleaned the blood off her body. No, there was blood and mud both on her body when she was found.
But she hid the axe.
She probably just threw the axe in the garden.
If she would have threw the axe, the Colonel Chirag would have seen it. But
not necessary. The garden, it's not necessary. The police thinks it's hidden. That's their case. But there is a possibility that she must have thrown it in the bushes, something you do. In such a state of shock, you don't really judge where to throw something or not, right?
But the forensic report held the fingerprints of her.
We are not denying that she used the axe to kill him. She did. But then,
It was an insanity.
and we don't think that she actually hid it. She just threw it somewhere.
She threw threw it, but it was seen that it was a hidden axe and it was recovered by the police. She didn't portray that she had done it. Instead, when she came out of the mania, she was still like she's done nothing, but she had murdered. So
And if she really wanted to hide the axe, she would have never accepted this in front of the police that there was an axe in her hand.
Correct.
Why would she accept it in front of the police if she really wanted to hide the murder weapon?
if she would not she knew that she had the axe in her hand, and it is very obvious that if there is a murder case, there would be various investigations. So forensic report was a must thing, but Vishy could have thought that if she didn't just confess it, it would be seen automatically from the forensic report. She preferred that she could tell the inspector or the investigating officer that the axe which she had was this incident happened due to a manic stage, but it was not proven. She wanted to plead against, but if she wouldn't have confessed it, it was clearly seen that the forensic report would clearly have told the investigating officer that Vishy was the criminal.
So it was all a plan.
Yeah. Thank you, Lordship. Next, the council would now like to state the second argument, that is the validity of Section 84.
Validity or
Applicability of Section 84. As seen above, Vishy was reasonable enough to understand that she had killed, but she portrayed that she had not done anything, and she was trying to plead in the dominance of her bipolar affective disorder, due to which and stated that the unconscious body of Soham on the floor was when she came inside, and when Colonel Chirag entered, he was alarmed with it and found. Court, please, could you extend my time for a minute or so? So, if we refer to the second case present on page 10.2, Surendra Mishra versus State of Jharkhand, Supreme Court case, where it is stated that she was suffering from a medical insanity. She had the problem of a bipolar affective disorder, and you can't equate medical insanity with a legal insanity. So the case literally underlines that the mental illness did not meet the threshold of legal insanity, that is incapability of the person to understand what the nature of that.
Can you please explain what happens to a person who's suffering from bipolar affective disorder?
So a person who's suffering from bipolar affective disorder generally gets very violent, has moments of rage, behaves in a subtle way.
So these people get violent, they have aggression, they act erratically, right? And because she was suffering from all these three, is there a slight possibility that these three would have been there happening to her because of which she did this? Slightest possibility, 1% chance?
No, sir.
Not even 1% chance.
Sir.
Why do you think so?
Because it was her intent. As proven above, it was a deliberate action. That
deliberate action which was driven by this insanity, the Dora.
So that's what. It was a deliberate action. And
Which was driven by this insanity.
No, it was like it was proven above only that the axe which she used was premeditated and planned. So
Why can't it so happen that the axe was lying there in the bedroom, and because of when she got angry, she just got hold of the axe and hit the boy?
Sir, actually no one keeps a axe in the bedroom. It is for a specific purpose, and it should be in a garden or somewhere in the storage place.
I am mad enough, I keep it as a decorative item.
Sir, ma'am, your ladyship, actually there's a kid in the house. How could you keep it as a decorative item?
हाँ करेक्ट.
But then if he gets hurt,
कैसे उड़ के थोड़ी एक्स उसके सर पे गलेगा.
if it,
He can jump. पैर पे कोला.
but it is not a common man would not generally keep it here.
हाँ, she is mad.
But
Is she?
there would be possibilities that not every time, maybe the baby is very small, he's 2 months old, but if the decorative item falls and he gets hurt,
What if she has kept it for self-defense?
it is not a tool used for self-defense. Self-defense is self-defense.
Self-defense के tools are also decided.
It is
पत्थर
for a
कंकड़.
specific purpose like gardening and things. How can it be used for self-defense?
अच्छा, ऐसे मानते हैं कि उसको गुस्सा आया, वो गुस्से में तन्नाती हुई गार्डन में गई. गार्डन में पहली चीज उसको एक्स दिखी, गुस्से में आई लेके सर पे मार दिया.
But she was sitting there.
Where?
She was
Where?
she was sitting in the bedroom.
How do you know that?
Stated in the facts.
Okay, then from the bedroom. Body bedroom में
She
मिली.
confessed it that when she was out of it, she was sitting there. So before it and after it, she was sitting
Okay,
there.
in the bedroom. हाँ ठीक फिर.
फिर क्या?
But I believe कि मान लो उनका बेडरूम में झगड़ा हुआ, वो गुस्से में तन्नाती हुई एकदम गई. जैसे ही गार्डन में पहुंची उसको एक्स दिखा, उसने उठाया लेके सर पे मार दिया. बट देन शी लाइक ओ शिट, मर गया आप. तब शी रियलाइज कि अरे बाप रे मुझे फिर से मिर्गी का दौरा आया.
But उसको दौरा आया ही नहीं था. Point.
That is what I am saying. How do you prove that कि उसको दौरा नहीं आया था? Because we are very well convinced कि दौरा आया था.
She didn't have that legal insanity. She
What is legal insanity?
incapable of understanding the nature of the act.
Got it? समझ ही नहीं रही है.
And what is medical insanity?
Which she had bipolar affective disorder.
So what is the difference between the both?
Bipolar affective disorder is a
ना ना ना, medical insanity, legal insanity, इन दोनों में difference क्या है?
इस साली बैड इसको खुद है.
legal insanity was that she didn't have the capability. Legal insanity is basically that a person does not have a capability to understand the
तेरी माँ की तो आई गया मुंह पे.
So legal insanity is basically that a person is incapable of understanding the act, while mental insanity is basically mental illness which a person is suffering.
So basic.
Yes.
I have no more questions.
Thank you. The court would now like to move to the council. Sorry. The council would now like to plead for some remedies for my client.
You want to go to the prayer?
Yeah.
हाँ. नहीं, उसके बाद prayer याद. Go.
So basically, the remedies which I would plead for my client are reconsideration of the sentencing of the punishment given by the High Court and the restitution order.
Restitution order?
Yeah. That the loss suffered by Soham's family should be recovered by Vishimata.
पति कैसे पैदा करेगी यार? You already killed.
How can you restitute a person's life?
So it's basically that maybe Soham was the only earning person in the family, and the whole house was dependent on him. So basically,
Shut up, shut up. समझ नहीं रहे हो, उसको गुस्सा आ रहा है.
Do we give restitutions in cases of criminal cases?
why not?
Restitution, what is restitution?
To compensate for the losses recovered.
To resurrect to the original position.
Compensation we give in criminal cases.
Yes. Now, in the light of the facts stated, issues raised, arguments advanced, and authority cited, it is most humbly prayed before the court, before the Honorable Court, to grant reconsideration of sentencing of the punishment under Section 302 and pass any other order that the court may deem fit in the interest of. Yeah.
पति लाओ ना दूसरा.
That the court may deem fit in the interest of justice.
What should we do with the child?
Keep it with the government. Keep him. keep him with a government childcare center, or basically you can give it to the Soham's. You can give him. You can give him to Soham's family, like her family.
Vishy's family.
Vishy's already proved in.
अरे विशी प्रूवन है ना, मम्मी पापा थोड़ी होते हैं.
She would obviously go there, and if कुछ हो गया तो
सोहम के घर नहीं जा पाएगी.
Why would she even opt to go there now?
After killing the child.
Yeah.
वो जेल में नहीं थी?
No.
अब तुम तो बोल रही जेल में डालो.
I am just asking the Honorable Court to make the sentence. I am not ordering them.
We will. डालो the jail. तब तो there is no problem in giving the child to Soham's parents.
Vishy's parents.
Sorry, Vishy's parents.
Nana Nani is more closer, no, rather than Dada Dadi.
It is subjective.
आपकी जान की कीमत बताओ.
हाँ यार, पैसे में मोल दिया इसने. Okay.
Any questions, Vishi ma'am?
Thank you.
Thank you.
गुड़िया, इनकी काली गाड़ी है नीचे 4626. कांच तोड़ दे बहन की आप. परेशान कर दिया उसको बेचारी को. हम उड़ाते हैं यार, बहुत देर हो गई है.
निकल गया. इतने बाल है, मैं क्या करूं? या
हेलो.
प्रॉब्लम क्या है ना?
If it may please the Honorable Court, this is Counsel Aditi Jallavar arguing on the behalf of Vishy Mathur in the case of State of India versus Vishy Mathur. If this Honorable Court may permit, the Counsel would like to make submissions to the Court.
Granted.
Thank you. If the Court may permit, the Counsel would like to state the facts of the case.
Skip the facts, we know the facts. Just move on to your issues. We'll not cut marks. We'll give you marks.
If the Court may permit, I would like to address one important fact of the case.
We will give you marks.
Okay. With due permission of the Court, I would like to raise the issues of the case. Thank you. First issue, whether Vishy Mathur was entitled to defense under Section 84 of ZPC. Second issue, whether Vishy Mathur was liable for the murder of her husband. Third issue, whether the High Court's acquittal of Vishy Mathur was correctly interpreted and applied by the High Court. If the Court permits, the Counsel would like to move to the arguments of the case. Thank you. First argument, applicability of Section 84. This section provides a defense for individuals who at the time of committing the offense were of unsound mind. There are two main requirements of Section 84. First requirement being the accused was suffering from a severe mental disorder. Second, the disorder rendered the accused incapable of understanding the nature of their act. Firstly, I'd like to prove that Vishy Mathur was actually a patient of bipolar affective disorder. As stated in the facts, after Harry was born, Soham noticed changes in Vishy's behavior. She started having fits of rage. There is also a scientific evidence that pregnancy or giving birth will trigger their first bipolar disorder. It's given, please refer to page number 20 of the compendium. Vishy might have bipolar disorder since the beginning, as she showed symptoms earlier also stated by her brother, but giving birth just triggered it. When a person has a manic episode, his emotions are heightened, which are marked by anger. Also, before the incident, Vishy was already diagnosed with bipolar affective disorder and started taking medicine for it. Even after the diagnosis and medication, Vishy still had moments of rage, which mean that the medication did not have 100% impact. So it is very strange not to believe that at the time of the incident, she wasn't going through the maniac episode. Also, on the day of the incident, Colonel Chirag heard noises from Soham and Vishy's house, which means that there was a loud altercation taking place between the couple. The altercation was such that it triggered the manic episode in Vishy, which led to losing her of all her senses as she does not remember anything about it. Studies also show that people who are having bipolar disorder, more than 50% of the people have experienced traumas in their life, which is a very significant number. Please refer to page number 16 of the compendium. So the fight that took place between the couple must have aggravated the bipolar disorder in Vishy. Additional research also reveals that there is a higher risk of violence during manic episodes. So, when in her defense, Vishy stated that she did not remember anything about the death of her husband, she wasn't of sound mind then. At the time of the incident, Vishy, under the manic episode, injured her husband because at that time she was incapable of knowing the nature of her act. In the case of Hari Singh versus State of Madhya Pradesh, page number 8 of the compendium, the Supreme Court held that there is no definition for unsound mind. It differs from person to person. It is very subjective to how a person reacts when he is in the maniac episode. There are generally 4 kinds of person who may be of unsound mind. There it is also written that a person may be non-compos mentis by his illness, is excused in criminal cases from such acts that are committed under the influence of his disorder. Here my client Vishy was under in the manic episode, thus she was non-compos mentis. In the case of Dayabai Chhaganbai Thakkar versus State of Gujarat, page number 10 of the compendium, the Supreme Court also stated that the burden of proof lies on the accused for proving the plea of insanity. But if the accused was not able to establish conclusively that he was insane, even if there is a reasonable doubt created in the mind of the court, he would be entitled to be acquitted. Here, my lordship and my ladyship, my client was in a manic episode, or else why should she even kill her husband? It was only the childbirth and the altercation that triggered her disorder. Thus, my client was incapable of knowing the nature of her act.
Why was there an X in the room?
Ma'am, maybe the axe was in the garden and Vishy and Soham were
in the
in the
entire
garden.
house, you just got an X. This is a mere coincidence. Kulhadi hi mili, sarpamani.
If they were in the garden, axe is something that you generally keep in a garden. So maybe when Vishy...
But the body was found inside the bedroom. And she was found inside the bedroom.
She was found in the garden, covered...
She herself confessed that she was sitting near the body with the X in her hand when she slipped out of the mania attack.
Maybe when she slipped out of her maniac act, she realized the nature of the crime that she's done. So she was so panicked that she went and hid the axe.
Which means the incident happened in the garden. Incident happened in the bedroom. So why was the X in the bedroom?
Maybe they kept it for self-defense or anything.
What kind of self-defense?
If somebody enters, so they might have kept the axe in the...
Such dangerous instrument for self-defense, you will keep it in the bedroom.
It differs from person to person. If they don't have a gun, what else do they keep?
I don't keep anything.
You need a license for a gun. So if they don't have a gun, they'll keep axe or something sharp in the bedroom for their self-defense.
Very convenient.
Ma'am, here in this case, it was the axe.
But I think more convenient option is a knife then.
Now they've kept
That
axe.
is what I'm saying. I don't agree that it was for self-defense.
Maybe it was Soham who kept the axe in the first place.
Soham knows
for the defense.
His wife has a bipolar disorder.
Maybe it was for his own private defense then. Second issue of the case, whether Vishy Mathur is liable for...
Counsel, tell me one thing.
Yes, ma'am. Yes, your ladyship.
बेडरूम में होना कोइंसिडेंस नहीं था. पागल होके एग्जैक्टली सर पे मारना was not a coincidence. Maybe उसको वो भी समझ में नहीं आया. But when she slipped out of the maniac attack, right? She herself confessed that.
Yes.
Right? Why didn't she call an ambulance?
Maybe when she slipped, she was not 100% stable. She could not realize the nature.
She herself said that she slipped out of the maniac attack.
But that doesn't mean that she was 100% stable and she couldn't know what to do and what was right at the time.
But she was stable enough to understand that I have to hide the X.
Because she was panicked, seeing the blood and everything.
So she had that understanding कि ये छुपाना है, पर ambulance नहीं बुलाना है.
The state of mind to calculate, Vishy's state of mind is very hard to calculate right now because you cannot judge somebody's state of mind and what actions they might do or what actions they might not do. It was only her, whatever she thought was right, she did that.
And this is also coincidentally she thought कि X को छुपाना पहले ज़्यादा जरूरी है.
No, that was because she got panicked and everything, and that is the reason she did it. Also, maniac episode comes in relapse time. So maybe when she slipped out of it, she realized what she's done, but she was not 100% stable to know whether to call an ambulance, whether to sit beside Soham, or whether to hide the axe or not.
Okay.
Vishy did not have any intention of killing her husband. They just got into an altercation before the incident, which means the couple was in an argument about something. If Vishy wanted to kill her husband, she could have killed him at night or she would have run out of the house. Also, the point to be noted is that Vishy was seen in a very distressed state by the eyewitness, which means that when Vishy slipped out of her mania episode, she realized it later about what she's done. It is also evident that my client was taking treatment for her disorder, but she still suffered maniac episodes after the medications as well. So clearly there was no premeditated intention of killing somebody, or it was only in the impulsive decisions of the maniac episode that led to Soham's death. In Shrikant Anandrao Bhosle versus State of Maharashtra, the Supreme Court stated that the state of mind of accused is very important when he is committing the offense. The state of mind before and after the incident is also very important. My client was in a mania episode and all of her senses has exalted, which is very common in bipolar disorder. The code of conduct of the accused is also very important. In the case of Surendra Mishra versus State of Jharkhand, the Supreme Court observed that the accused has to prove his insanity during the incident. The court also should take into consideration the state of mind of the accused before and after the incident. The circumstantial evidence which need to be checked before the conduct of the offences are the medical history of the accused, no prior plans, no accomplices. Here, my lordship and my ladyship, my client had a medical history and she was also taking medication for it. My client did not have any prior plans nor the motive. There were no accomplices as nothing is stated. Hence, I presume her to be innocent.
Counsel, when you take the plea of 84, section 84, the burden of proof is on the accused
Yes.
to show that she was insane at that time. Can you tell me the level of proof that is required? Does the accused need to prove it beyond reasonable doubt?
No, sir. Only if he creates a reasonable doubt in the minds of the jury and the court, he is deemed to get acquittal from the High Court or the Supreme Court. The conduct of the accused after the offense, she did not abscond. Eyewitness, the conduct after the arrest. My lordship, after the incident, my client did not abscond anywhere. Instead, she was found in a very distressed state, crying in the garden by Colonel Chirag. Also, when the police arrested her, my client told them that she does not remember anything, which shows that she was unsound mind. She was of unsound mind then and lacked intent. Third issue of the case, whether High Court's acquittal was right. Legal insanity.
Counsel, could all of this be a part of a concocted plan?
No, sir, I don't think so.
Why?
Because it is not stated in the facts.
You have to derive it from the facts. Now, for me, it could be a plan that she knew she could get defense of 84, and that is why she killed him and started doing all this drama in the garden so that she can build up her story later.
No, sir, I don't think so. That's true because in the facts it's also stated that Soham and Vishy also had a blissful married life. It was only after the birth of Harry that led Vishy to fits of rage. Legal insanity. In legal insanity, the person doing the offense cannot understand the nature of the act that he is doing. Plus, he has the incapacity of not knowing whether his actions are right or contrary to the law. My client Vishy, due to her maniac episode, did not know the nature of her act. Plus, the mania episode impaired her mind in understanding what is right or what is contrary to the law. Thus, my client was legally insane during the event. It is the fundamental principle of criminal jurisprudence that an accused is presumed to be innocent. My client was in a mania episode and she herself did not realize the nature of her act. Plus, there was also the expert testimony of Dr. Amruta, who knew Vishy and she was also treating Vishy for the mental disorder. Thus, I feel that the High Court's acquittal was right. Also, in the scientific evidence is given on page number 17, bipolar disorder and violence, it says that bipolar patients are prone to agitation, which can increase the risk of violent behavior. Bipolar patients have chronic impulsivity, which means their actions are very impulsive. Thus, it shows that Vishy had no intent. It was only the impulsive decisions that led to the death of her husband. The patients in mania episode have increased impulsive aggression and their ability to control these impulsions also decrease. If the court is satisfied, the counsel would like to move on to the prayer. In the lights of the facts stated, issues raised, arguments advanced and authorities cited, it is most humbly prayed before the Honorable Court to uphold High Court's decision of acquittal of Vishy Mathur, and please provide her treatment at a rehab center. Also, to allow her supervised visitation to her son, Harry, and it may pass any other order that it may deem fit in the light of justice, equality, and good consciousness. Thank you so much.
And now we have one last participant who's gonna come here and present their case. The last participant is Misha Savot. She'll be representing State of Zindia in the matter of State of Zindia versus Vishy Mathur.
Good afternoon. If it may please the Honorable Court, this is Counsel Misha Savot, arguing on behalf of the state in the case of State of Zindia versus Vishy Mathur. If your Lordship and Leadership may permit, I would like to give the submissions to the Court. If the bench might permit, I would like to get on with the facts. Even 3 important facts. Oh, yes. So I'd like to directly move on with the issues. So the very first issue is whether the High Court erred in acquitting the respondent, Vishy Mathur, based on the plea of insanity under Section 84 of ZPC, whether it could be established without a doubt that Vishy Mathur was insane at the time of committing the crime, whether the evidence presented by the prosecution established beyond a reasonable doubt that the respondent committed the offense with full knowledge and intent, thereby negating the applicability of Section 84 of the IPC. If the bench might permit, I would like to move on with the arguments. Okay. The very worst argument is whether defense of insanity under Section 84 is applicable. So the Honorable High Court erred in saying that respondent is legally insane without taking into account sufficient evidence. High Court acquitted the respondent on the testimony of Dr. Amrita, where she contended that respondent is suffering from bipolar disorder, but she failed to take into account the other evidences and circumstantial evidences, and that's why the High Court was mistaken there. However, Dr. Amrita did say that the respondent has bipolar disorder, and the bipolar disorder is sufficient to enable a person to do any act under its influence. However, respondent's diagnosis of BPD does not automatically qualify as legal insanity under Section 84. This was stated in the case of Dayabhai Chhaganbhai Thakur versus State of Gujarat, where the Supreme Court said that where a plea of legal insanity is set up, the court has to consider whether the time of commission of the offense, the accused, by reason of unsoundness of mind, was incapable of knowing the nature of the act and was doing so what he was doing was either wrong or contrary to the law. The crucial point of time for asserting the state of mind of the accused of the time is when the offense was committed, whether the accused was in such state of mind where state of mind has to be entitled to the benefit of Section 84 of the Indian Penal Code, and it can only be established from the circumstances which preceded, attended, and followed the crime. It was further also elaborated in the similar judgment of Amrit Bhushan Gupta versus Union of India, where it was held that unless the court comes to the conclusion that the accused was insane at the point of time he committed the offense, he cannot be absolved of the responsibility of the offense, even it is found by the court that he was insane either earlier or later point of the time of the commission of offense. We cannot really prove that at the time of committing the offense, she was legally insane. She was medically insane, okay, because she was under the care of Dr. Amrita, her psychiatrist, but it is... legal insanity means that incapability of a person to understand the nature and consequences of his actions at the time when he's committing the crime. And medical insanity needs to be, a person can be subjected to medical insanity when he is under fits of rage or he is not in his full consciousness at any point of time. It doesn't really matter. What court really needs to decide is at the time of committing the crime, was he insane or not?
Sorry.
It's okay.
No, my point was this proposition held in Amrit Bhushan Gupta, apply that to your case. Current case wherein Vishy is being accused of killing Soham.
Where Vishy is accused of killing Soham. There was no eyewitness. There was dying declaration. Prosecution witness one said in Soham's dying declaration, he said that
Vishy killed him.
Vishy killed Soham, but there is no eyewitness as such. Therefore, we have to look at her behavior before committing the crime and after committing the crime, because there is no eyewitness. We cannot really be sure if she was insane at that point of time or not. So, according to her, before committing the crime, they were in the facts it is written that she was, there was already a fight going on between the two as per the statement of Colonel Chirag. And he said that he heard noises coming from their house. So he went and checked on them. And when he went and checked on them, the Soham was lying unconscious on the floor. Vishy probably, so the murder weapon is found to be an axe, which, first of all, why would someone have an axe in the house where there is a 2-month-old?
Gardening.
But you do not really use axe in the gardening. Axe is used for cutting big trees with a trunk and all.
Oh, my garden does not have big trees.
Okay, let's give the benefit of doubt. She did have an axe, but for sure, she did not have an axe in the bedroom. And if she's
People
really
can
insane,
keep axe in the bedroom also, no, as a weapon for self-defense. What if
An
Soham
axe.
kept it as a weapon for self-defense, defending himself against
no
Vishy?
person or reasonable person would keep an axe in their bedroom for self-defense. You might probably keep a knife or a gun, which is easily...
Gun is not easy to get.
License.
But at least it can be kept hidden away. You cannot really... Axe is something which is...
Under the bed.
But that's what.
They can keep it under the bed, no? Hide it under the bed.
So nobody really keeps axe in their bedroom. Let's be real.
That is a very personal choice.
Oh, correct.
But who have you? You would have listened that people keep guns in their houses, licensed, non-licensed. That's another thing.
Eggs in my bedroom for decoration.
That's a different thing. It would not be very lethal then.
No, it is.
Yeah, there can be other uses also, no, of the axe. So, play.
उसके लिए भी 2 चाहिए, but ठीक है. Okay, so nobody really keeps up. If even there was self-defense, the only fingerprints.
No, understands that his wife is suffering from bipolar affective disorder.
हाँ, it's his.
उसको पता है कभी मार दिया तो इससे बेटर है कि रखूँ ना self defense.
वही तो वो bipolar में है. सब तब भी एक्स रखा. एक तो बच्चा है छोटा, उसके साथ बीवी भी पागल है.
वही तो. बीवी पागल है, ढाके कभी किसी दिन मारने लगी तो होनी चाहिए ना कुलाई डिफेंड करने.
बीवी ने ही लेके मार दिया तो what would you do? Which she actually did. गुस्से में आके.
अब उतना उसने नहीं सोचा.
पागल होके नहीं. उस टाइम पे पागल नहीं थी. पहले तो वो कहीं पहले झगड़ा चल रहा था बेडरूम में. They were in the bedroom fighting.
हाँ कि झगड़ा बेडरूम में चल रहा था.
Okay, probably the loud noises coming from the house. Colonel Chilla came and he saw the body of Soham lying
In the
unconscious.
bedroom. हाँ.
That means they were already in a fight before whatever happened. Whenever they were, she must have bought the axe from somewhere, and she might have strike him with the axe. First of all, if she has that much knowledge that she has to go somewhere and get an axe to kill her husband and strike him with that kind of blow, she has to have that intent that it would kill him, because an axe is a deadly weapon. If she's bringing an axe and striking him with it, that means that she intend to kill him. That's why too, yeah.
Time.
May I get a few more minutes?
Yes, but I have a story. आप उसको डिफेंड कर दो एक बार प्लीज.
Okay.
तो मान लो ये तो पता नहीं है कि झगड़ा कहाँ पे हो रहा है, ठीक है. मान लीजिए झगड़ा गार्डन के आसपास हो रहा था, बहुत जोर से झगड़ा हुआ, ठीक है. विशी का दिमाग हिल गया, ठीक है. वो झगड़ा होने के बाद क्या नाम था, सोहम गुस्से में बेडरूम की तरफ गया तन्नाता हुआ, और ये जो भी झगड़ा हो रहा था वो गार्डन के पास था. गार्डन के पास उसका एक्स दिखाई दिया, उसने एक्स उठाया, गुस्से में उसके पीछे गई, मार दिया बेडरूम में, वो मर गया.
तो वो सोहम जा रहा था, तब वो झगड़ा चल रहा होगा, कुछ ना कुछ एक दूसरे को बोल रहे होते, स्क्रैच इंजरीज भी थी उसकी बॉडी पे, मतलब फिजिकल ऑल्टरकेशन हुए होंगे. वो अगर गई भी हो गया.
हाँ, किसने सेल्ड मेरी कहानी बढ़िया है, ये पहले नहीं आई यार. ये एक जज को चाय पिलाई जाए प्लीज. Yes, ma'am.
Soham was going into the bedroom.
हाँ, सोहम इज गोइंग इनटू द बेडरूम. वो गुस्से में दौड़ती हुई आई, तो गुस्सा ही उसने मार दिया.
तो उसमें इतना दिमाग है, लेट्स से फॉर एग्जांपल उस टाइम पे वो पागल थी, उसमें इतना दिमाग था, शी बॉट एन एक्स, जहाँ भी था वहाँ
वो
से
तो झगड़ा ही वहाँ पे हो रहा था ना, सामने दिख गया.
तो वो जा रही थी, तब तो समझना चाहिए ना, तो ये तो डेफिनेटली मरेगा, मतलब उसका वही intent
अरे नहीं
था
समझ रहा
मारना.
ना, उसको वही तो
अगर
प्रॉब्लम
पागल
है.
होती, किसी भी चीज से मारती.
अच्छा, उसके पास मोटिव क्या है उसको मारने के लिए, आप ये बताओ.
तो जरूरी थोड़ी मोटिव नहीं है.
मोटिव तो जरूरी होता है.
से अब्सॉर्ब कर दोगे.
क्राइम के लिए मोटिव जरूरी नहीं होता. नहीं, अरे
Just a minute, I would need a
गजब, ये बहनें हैं क्या दोनों?
In Sherawali Mohammed versus State of Maharashtra, it was stated by the Supreme Court, the mere fact that no motive has been proved by the accused murdered his wife and child, or the fact that he made no attempt to run away when the door was broken, would not indicate that he was insane or that he did not have the necessary mens rea for commission of the crime. Motive वैसे भी prove होता है when you do the action. The mind of the guilty person is judged by his actions and not the other way around. हाँ, जरूरी नहीं है, मतलब जरूरी है, but how would you?
But crime का the major ingredient is mens rea ना. How do you prove mens rea? Motive, intention and knowledge.
Intention जरूरी है.
Motive and knowledge.
Motive and?
Motive, intention और knowledge. Intention prove हुआ तो ठीक है, motive to prove हुआ तो ठीक है, knowledge prove हुआ तो ठीक है.
But it is given. If you're taking the defense of Section 84, you have to prove that you are legally insane at that point of time. Beyond reasonable doubt. Yeah. You were not insane. You were insane to get the defense of 84. Yes. नहीं, उल्टा है. अगर थोड़ा भी बोल दिया तो the court would acquit the person. Yes. I'm sorry.
So you have to prove it beyond reasonable doubt, right?
ये तो उसके actions पहले हो गए. बाद में भी it was when the authorities came. First of all, she didn't have enough time to even run away. She tried to hide the act. She was covered in blood and mud. What takes more time, hiding something or just running away, fleeing the scene? Fleeing the scene, but probably her plan was कि पहले hide कर देते हैं and then भागेंगे. But उतने में neighbor आ गया, तो she didn't
बट
have
अगर वो
much time.
भागी रही थी तो एक्स लेके भाग जाती है ना और बाहर कहीं फेंकती अपने ही
तो
गार्डन
बाकी
में.
neighbors को भी तो दिख जाता कि एक्स लेके भाग रही है. It would be very,
Oh, she has a point. Right.
yeah. So उसके बाद भी when the authorities came and she was interrogated, it was very easy for her to say कि अरे I did not know what I was doing. I did not know from where the ex came from. उसने ये भी नहीं बताया हमारा झगड़ा क्यों हुआ, कैसे हुआ. She just pled कि I do not know how it happened. So easy for her to say कि मैं तो पागल थी.
But if she really wanted to hide the axe, why would she go and tell the police that I had an axe?
The police found that.
No. She said in her statement that she didn't know from where the axe came to into her hands.
Yeah, but the police came and they found the axe in the garden. They might have asked because the murder weapon is the axe. That's
Okay. You go ahead.
Second argument.
Huh? Murder weapon is not axe. My brother judge does not believe.
But the fingerprint were found in the axe.
Because
Axe
she
was
used it
hidden.
for gardening, no? One day.
But it was covered in blood and mud.
She was covered in blood. Axe wasn't
was
covered.
also covered in blood.
No, where is it given?
Also, if even odd.
No,
the
where is it
fingerprints
given
were
that
found.
axe was covered in blood?
Even if she was gardening कब करी थी पहले तो gardening करवा के छुपा दिया है. Nobody hides the axe after.
Because there's a small child at home now.
It's 2 months old. It's not going to do anything. But only Vishy's fingerprints were found. Matlab, that means that she might have taken at that point of time the axe and hit.
Or
hit
maybe
it.
she was the one who was actually responsible for doing the gardening stuff. And Soham never helped in the gardening. Actually, that could be a reason why they had that fight.
That's a domestic problem then. Murder तो नहीं करना चाहिए था. But किया ना उसने.
अभी क्या करेगी क्या कह सकते हैं.
वही तो ऐसा थोड़ी कुछ भी कर सकते हैं मतलब उस टाइम पे तो उसको गुस्सा आया इसलिए उसने मारा मतलब her intent was to kill him. She was not in her episode. That's what I'm trying to say. But then what is the murder weapon?
स्टेट की रिस्पॉन्सिबिलिटी थोड़ी है, आपकी रिस्पॉन्सिबिलिटी है. व्हाट इज द मर्डर वेपन? टेल हर.
Which is an axe. Large, sharp, which is an axe.
Axe is
And
छोटू सा.
even Dr. Ghai, who is a prosecution witness, he also said that the axe that was found, it was sufficient to cause the kind of injury Soham had.
So that way, the Dr. Amruta also said that her bimari, Vishy's
But
bimari
how
was
did she know? She wasn't there
How
at the
did
time
Dr.
of the
Ghai know?
crime. He postmortem report में था वो.
Huh?
It was in the postmortem. He operated on the deceased before he finally succumbed to his injuries.
Are you carrying any sharp object?
Okay. हाँ, ब्लैक कलर की सरिता.
हम तो कुछ पूछ ही नहीं रहे पर अब.
CRETA सरिता. वो बोल रहे थे.
6484 I-20.
चलो कंटिन्यू.
And anyway, it can be proved that.
My sister judge has a very important question. If there was actually blood, that's a very good question. थोड़ा पहले पूछना था. So if you are saying that the murder weapon was an axe, ठीक है? In the forensic report, there should be something which says that there was blood on the axe. They found fingerprints of Vishy on the axe, but they could not find any blood traces on the axe. Now, if you will come and tell me that Vishy cleaned the axe before she hid it, then that will be stretching it too much, right?
She could have, matlab,
She
cannot
couldn't
rule out
clean
the
herself, she
possibility.
cleaned the axe.
She might have thought ki you have killed her husband. He's unconscious.
Being on the prosecution side, you cannot put doubts. You have to prove it.
Beyond reasonable doubt. You understand my question?
But she did say it in her statement in the interrogation that when I came out of the mania, which she probably said
During
because-
interrogation, no. That is 161 statement. It's not admissible in the court of law.
But even in the court, she said when the trial court was going on, she said
No. She said
she pleaded that she was in the minutes written 2 times.
Where exactly?
Can I come?
Wow, yes. One is here. She told the police that when she calmed down and started to slip out of her mania back into a normal state. सेकेंड टाइम का एक्स का कहाँ लिखा है?
But she was there. How and Soham died. That implies that the जो पहले बोला था वही she is going to say. If she is going to change her statements, मतलब she's.
Admissible as an
But if
evidence
it's
in the court of
facts,
law.
but if you're talking about being there, I'm sorry. If you're talking ki she said something else before to the police, and then she said the same thing in the court, but she just didn't mention the murder weapon, which is the axe. You cannot really say that murder weapon wasn't the axe. She just before she said, and then by all the circumstantial evidences also prove that go towards the fact that the
Had
axe
you
was
been
murder weapon.
accused, तो मतलब कुछ भी doubt दिमाग में डालना was fine. But since you are from the side of prosecution, you have to prove beyond reasonable doubt. ये हो सकता था, या ऐसा हो सकता था. We cannot accept that.
But ma'am, circumstantial evidence तो लेना ही पड़ेगा ना. You have to consider circumstantial evidence. There was dying declaration that the cause of Soham's death was Vishy. He said in his dying declaration, and dying declaration
is admissible under what section?
32 of Indian Evidence Act.
Now, counsel, 3 points why you think Vishy is guilty. 3 points. Just 3 points.
Points. First of all, they were already in a fight. She bought in the axe from somewhere, wherever it was, and she hit him with the axe, which caused him to die. First of all, it clearly proves that she had the intention to kill him. If she didn't, she just wanted to harm him. She might have used some other things to hit him or anything. She didn't. And then second, she tried to hide the axe also. She probably didn't run away because she probably didn't have much time. But then again, she did try to hide the axe. And then when police was called, it was very easy for her to say that, oh, I am insane. It probably feels like she's trying to escape her liability by stating that she is insane, which is even worse. And third, because of prosecution witness, because of the post-mortem reports and forensic reports, her fingerprints were found on the axe. The Dr. Ghai said, who operated on the deceased, also said that axe was enough to cause the death of the deceased as well. I think that's it. In light of the argument advanced in the issue raised, it is most respectfully prayed for before this honorable court that to set aside the judgment of acquittal passed by the High Court of India, reinstate the conviction of respondent under section 302 of ZPC, and pass any other orders as the honorable court may deem fit. And thank you.
So guys, this was our last participant for today. With this, we come to an end of all the presentations of the finalists. We'll end this session right now. Reconvene in 15 minutes with your results. We'll have our prize distribution felicitation in 15 minutes. All right. Online वाले बच्चों, आप लोग को एक नया लिंक आएगा and उसमें अपने prize distribution results देख सकते हैं. ठीक है? Thank you so much, guys. See you guys in 15 minutes. Bye.